Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. I insist that it be a Super Friday because it's been a long couple of weeks, and I think we all need it. Apologies for yesterday not being able to join you. A serious technical snafu at the last moment shut things down. Spent about 4 hours rebuilding yesterday, though, and I think things are working now. Fingers and toes crossed. Let's start our day with Mindy Glazer. Always good times in Miami-Dade.
Thank you.
Okay, so he reviews court. When we see him later, we will decide what the appropriate bond should be, but I made note of what you're requesting.
Thank you, Your Honor.
Let me just review for probable cause. So you had a cylindrical tube.
Yes, like a stake, a metal stake.
What did he hit the victim with that he's charged with aggravated battery?
It's like a metal stake, kind of like a nail rod, but large, metal nail rod or steel.
A large metal nail rod for what?
It's either out of steel or metal.
Oh.
Like a piece
How
of
big is it?
rebar? Can you describe it a little as best you can?
It would be like basically like a maybe 2 to 3 foot, 3-foot nail, like a nail rod, like a metal rod,
Oh, okay.
but with a sharp corner, sharp edge.
Ms. Corey, do you have any questions for the officer?
No, Judge, thank you.
So I'll find probable cause on F-25-252 51 for aggravated battery. Second.
Which one, Your Honor?
I'm on F, just finding probable cause F-25-25251. I'm just looking for the drug paraphernalia.
I'd ask to find no probable cause for the paraphernalia.
It said that a cylindrical tube. So it looks like it was a pipe. Do you know if there's any residue on the pipe, officer?
I wasn't there at that. I was
Okay.
dealing with the victim. I was not
Okay.
there.
No problem.
One minute. Probable cause though for the false leave after arrest. Probable cause for 1 and 3. Reset it for the afternoon.
Thank you, Your Honor.
And then we have the other cases. Mr. Alexander, what do you hear on which one? Both of these others?
Yes, ma'am. I am not sure if they both stem from the same A form. Devin Alexander on behalf of victim CBS. I am not sure if they stem from the same A form, but there is one A form that was incorrectly charged. It was only charged with 1 petty theft, 2 or more convictions, and it should have been 2. There is probable cause, and there are 2 counts on.
Judge, who are you calling?
I'm still on Zachariah Spine Skinner for his other 2 cases. I have the victim representative from CVS coming in to tell me what he wants to do on behalf of his client, what he's asking for.
Yes, ma'am. So I just wanted to point that out. But he, in this A form that I received last night from the officers, on 2 different occasions, he stole, I believe, soda streams, which are 2 pretty expensive items. And I just wanted to note, around this time of year, the managers in these stores are judged heavily on what they can sell, what is stolen from them, which might not be fair, but that is the nature of the beast. So it is more impactful than it may seem on the A form. So we do request, obviously, a stay away order, and we'll defer to Ms. F on what she believes that the bond should be, but we would ask that it's elevated just then higher than standard.
Thank you. Okay, he's not here,
Okay.
so I'll reset it for the afternoon.
Yes, Your Honor. Thank you so much.
There's probable cause in F-25-25271 for petty theft or more convictions. Let me take the other case. So it's, what is it? Oh, Savage Xfinity. Sorry, I got it. All right, so the other case, there is probable cause for also petty theft. 1 second. Well, it says new prior convictions and give a case number. That's good enough for me. Reset the afternoon, all 3 cases.
Yeah, I'd be excused, Your Honor.
Your excuse, thank you.
Thank you, Your Honor. Have a good weekend.
You too. Okay, this now.
This is Yohan Lopez, page 4.
Yohan Lopez, private attorney. Can you raise your hand? Who is it? Thank you. I got 2 lawyers. Oh, and the bondsman. You got a bondsman here. Thank you for the bondsman raising your hand.
Spanish interpreter, please.
Spanish. Good morning, sir. You were arrested for burglary to an unoccupied conveyance. I'm sorry, burglary to an unoccupied dwelling, dealing in stolen property, grand theft, a 2nd-degree felony, and unlawful use of a communications device.
Good morning, Your Honor.
Buenos días, usted enfrenta varios cargos, solo uno tiene que ver con hurto mayor, tiene que ver con ingreso ilícito a una vivienda desocupada y también por tenencia ilícita de un dispositivo de comunicaciones
And also criminal mischief.
y también por daño en propiedad, fechoría.
Your attorney is present. Can you state your name for the record, please?
Attorney Arturo Taquechel on his behalf, Your Honor. Good morning.
Se acaba de presentar el abogado que lo está representando.
Good morning. I also have in court, are you police officers?
Yes, detectives.
Detective, please raise your right hand to be sworn. Do you swear or affirm, there's 2 detectives. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Está también presente el oficial que acaba de presentar juramento.
All right, detectives, I guess I'll start with you. What is your name, please?
Detective Jonathan Gross.
Okay. And who are you?
Detective Juan Segovia. I'm a sheriff.
Thank you.
Se acaban de presentar 2 detectives que están ahí presentes en el juzgado.
All right, so let me give me a moment to review this arrest affidavit for probable cause. So this is an incident that goes back to September 12th of 2025.
Este incidente se remonta al 12 de septiembre del 2025.
So in the last 5 years, I've never met this moment. So wild was $10,000. Most ever met. July 15th. $2.3 million. I did that. We just go wild. That's why we can't be paid for the holiday.
Okay, I had a chance to review the arrest affidavit. Detective Grossman, what do you want to tell us?
Acabo de leer el informe del arresto, dice la juez, y le pregunta al detective qué quisiera el detective decir.
We're just here in the event the state needed anything.
Estamos acá solamente en caso de que la fiscalía necesite algo.
What were the damages to the amount of damages to the victim's apartment? There's no amount of damage to it.
My understanding.
La juez pregunta a la fiscalía cuál es la cantidad de daños que sufrió el apartamento de la víctima.
It was a door lock. I believe they estimated it on the charge between 200 and less than 1,000.
Okay.
I'm sorry, but what was that again, please?
That it was estimated between 200 but less than 1,000. I think it's what.
Fue entre 2,000, entre 200 y 2,000.
There was no value listed in the body, the store narrative.
I'm sorry. That's my understanding.
Okay. All right, so you don't. All right, any questions for the detectives?
No questions, just argument, Judge, whenever the court's ready.
Okay.
La fiscal no tiene preguntas, solamente un argumento.
And Mr. Takashil, did you have any questions for the two
I do.
deputies?
I do not, Your Honor.
El abogado tampoco tiene preguntas para el detective.
All right, so,
Judge,
sir, 1 second, sir, you are ordered to stay away from the victims. You want what's the victim's initials? Please? State.
victim's initials are ADH.
Stay away from the alleged victim whose initials are ADH.
Tiene que mantenerse alejado del orden a la juez de la víctima cuyas iniciales son ADH.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Puede contactar a esta víctima ni directa ni indirectamente, tampoco en persona, ni por teléfono, ni a través de terceros, ni por escrito.
No contact with the victim through social media or other electronic means.
No podrá contactar a la víctima a través de las redes sociales ni por ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Y en todo momento se tendrá que mantener alejado por lo menos a 500 pies de donde la víctima vive, trabaja o estudia.
And you must stay away from his victim's residence at 1032 Northwest 87th Avenue in Miami, Florida.
Y en todo momento tendrá que mantenerse alejado de la casa de la víctima que queda en el 1037 de la 82 de la George 87th Avenue, right?
87th Avenue, yes.
Thank you, Honor. De la avenida 87 de Miami, Florida.
Okay. Do you understand the stay away order?
Señor, ¿usted entiende la orden de alejamiento?
All right. I had one
Judge, the
question.
state's requesting an increased bond on this case. It looks like they cased the residence and burglarized the house, a house that appears to be, very expensive jewelry.
Really? I don't see a
I
value
don't know
for
if
jewelry.
it talks about diamond. It talks about diamond jewelry and a
Where does
Rolex.
it say the value of the jewelry on here? I don't see it.
So
It
detectives,
says Rolex watches. I don't know. How do I know it's real? Is it Detective Segovia?
Yes, Your
What's the
Honor.
value of the jewelry that was the victim?
Your Honor, I do not know. We were assisting the Midwest District. What I wanted to tell you was that this is a very well organized and sophisticated group of burglars that have been terrorizing the area. The last time this group was taken down about approximately 2 years ago, the percentage of burglaries that went down in Midwest District for Miami-Dade Sheriff's Office was 68% just from taking this group down. 2 years later.
Estos detectives, señoría, primero que todo, la fiscal está pidiendo una fianza elevada debido a la cantidad sustancial de joyas y relojes que sustrajeron de la vivienda. El detective dice, señoría, este individuo pertenece a una banda organizada que por los últimos 2 años ha venido aterrorizando el sector con
Well, can you call up Officer Mazza who wrote and find out the value? We'll pass the case for a minute. We need to find out the value of the merchandise that was taken.
para pasar el caso porque la jueza está pidiendo que se dé un desglose de la cantidad del avalúo de las joyas.
Have a seat. We'll be with you in a moment.
Thank you, Judge.
Tome asiento, van a volver a llamar su caso.
detectives are gonna call?
What?
I wanted to see if I needed to call or if the detectives are gonna call.
You what?
I wanted to
You're
see if
following up the detective who wrote the.
excellent. Thank you, Judge.
All right, next we have Manatha Paris, page 5, private attorney. So, here we go. Mr. Takashel, I'm putting you as an attendee since you're not putting off your camera. When you come here and I'm not on your case, you need to turn off your camera. But since you're not doing it,
Your Honor wants me to turn it off?
Until
yeah,
the case is recalled.
you need to know Zoom etiquette here. Turn off your camera until your case is.
Your Honor, that's for Paris, correct? I don't have that person as a.
Paris isn't here yet.
Oh,
Hi, Mr.
Malcolm
Mayberg.
Mayberg on behalf of Paris, so I'll wait.
He's not here yet. Can you get him so we can, the one from yesterday?
The third
They
roommate,
had
looks
3
like.
boys living in his house doing this? That's terrible.
Yes, Your Honor.
I'll pass the case. Out of turns for correction, sorry. Next, we have Gian Crespo, page 20. Also, there's family here for some cases. I'll try and get those. Did you get the value yet?
Yes.
When you're ready, I'm recalling Johan Lopez. They got the value. So bring in whoever you got. I'm out of control today with the organization. Let's be happy it's Friday. I got to pass your case. Oh, he's here now. All right, Mr. Mayberg, your client's here.
Good morning, Your
Yes,
Honor.
Mr. Harris, good morning. You were arrested for trafficking in amphetamines, trafficking. This is Mr. Crespo. Oh, it's Mr. Crespo. I'm sorry.
Number 62 on the calendar on page 20.
Pardon me, oh no. Mr. Crespo, you were arrested for escape, tampering with an electronic monitoring device, and criminal mischief. I will appoint the public defender's office for you. So count one, the escape, what do you want? An RO or a dollar?
$1.
Count one is $1. Count two is $2,000. Count three is $500. Have a nice day.
Welcome again, everybody. Happy Super Friday. It is the Courtroom Files. We are live. We are watching Judge Glazer kind of walk the line on a possible Friday meltdown already. We'll see how it goes. We'll stick with her for a few more minutes as other courts come online.
Okay. With Spanish interpreter. So, sir, we're back. The detectives or deputies walk back in the courtroom. Detective Grossman, hello, good morning.
Ya, señor, su caso lo están llamando de regreso. Aquí están los detectives presentes en la sala de juicio.
After conferring with the primary lead on the burglary case, it's estimated that the value of the items that were stolen was $30,000.
Se estima que el avalúo, la cuantía de los artículos robados asciende a los $30,000.
Okay, thank you.
That would make it a grand theft second.
What?
That would make it a grand theft second.
All right, Mr. Takashel, do you have any argument regarding your client and the bond this court should set?
No, Judge, I'd just like to request a standard bond be set and posted by him. He's not a risk of flight nor a danger to the community.
La juez le pregunta al abogado si tiene algún argumento. Él dice que no, él está pidiendo simplemente la fianza estándar. El abogado alega que él no, su representado no representa riesgo de fuga y no representa riesgo para la comunidad.
He had numerous arrests back in 2013 for burglaries and grand theft and criminal mischief, and it looks like he got 3 years in prison.
That's correct, Your Honor.
Bueno, desde el 2013, este acusado ya fue arrestado varias veces por ingresos ilícitos a viviendas y también por hurto mayor. El abogado confirma esa información.
And then there's, he just got off of probation earlier this year. It looks like grand theft of a vehicle, resisting without, and offenses against computer users.
De hecho, ya había terminado libertad probatoria a comienzos de este año por hurto mayor de un vehículo y también por resistirse sin violencia.
Corrections, does he have any immigration holds or no?
No, he does not.
No, Judge.
No tiene orden de retención migratoria.
All right.
So the state's requesting a $50,000 bond on the burglary based upon these facts, as well as the defendant's criminal history.
Entonces, a la luz de estos hechos y del historial criminal de este acusado, la fiscalía está pidiendo una fianza de $50,000 por el delito de ingreso ilícito.
Also requesting Nebia and house arrest.
Y también una audiencia tipo Nebia y arresto domiciliario.
It's overkill, Your Honor. Once again, I request Your Honor set a standard bond, and that would be sufficient to guarantee his presence in court.
El abogado dice que no amerita tal cantidad, que la fianza estándar es suficiente y que para que garantice que regrese a comparecer por estos cargos.
He's a signal 100. I'm setting a bond count one burglary to the unoccupied dwelling is $50,000 bond. Count two dealing in stolen property will be $2,500. Count three grand theft. I'm splitting 2 and 3. You can't be convicted of both. $5,000.
Entonces, por el primer cargo, por ingreso ilícito, $50,000 de fianza. Por el segundo, por comercializar con mercancía robada, $2,500. Por el tercer y el cuarto, $5,000.
Count four unlawful use of a communications device is a third-degree felony. That's $2,500. And count 5 criminal mischief, no value, $150.
Por el cuarto son $2,500 y por el quinto, Your Honor, for the interpreter for the fifth one, how much is it again, please?
$150 for count 5.
Got it. Thank you, Judge. Y $150 por el número 5.
Also, it's house arrest with a GPS monitor, level 3 house arrest.
La juez le impone también arresto domiciliario nivel 3.
And no curfew and a Nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Se le impone también un requisito Navia para demostrar que los fondos que va a usar para pagar esta fianza vienen de un fondo legítimo.
Was you gonna do the curfew? It looks like he
No, I
broke.
didn't do a curfew. He's doing this during the day.
Curfew.
He's not, Judge.
He's not? Is it doing a curfew or
So
no?
the victims said at 9:30 in the morning. Oh, hold on. Okay, you're right. He did.
It's a curfew, Judge. He's a grown man.
Well, that's to make sure there's no crime
I mean,
out and about. But
we've
it's
already
okay.
raised the standard bond. We've already put an ankle bracelet on him. We've,
I
you know,
didn't give him a curfew. I let him listen. He didn't have a monitor. That place where he sold it, did they sell the jewelry or they own that jewelry store in the Seabold?
So he would, the items were stolen and then he would go to the Seabold building and offload the.
Oh, okay. Have a nice day. Thank you, Mr. Tackett. You have a good lawyer.
Okay, that's a total of $60,000.
$150.
60,000, 150.
Right. Okay, thank you.
And it's a level 3 house arrest.
Level
correct?
3, it's just gonna wear a monitor. We're gonna know where he is.
Right, but it's rolling. Very good. Thank you, Judge.
También pondrán un grillete electrónico para saber dónde está.
Okay, now out of turn for corrections, unless you have Mr. Do you have Mr. Parrish yet?
Yes, we do.
Oh, bring in Mr. Paris. Okay, bye, Mr. Paris. He's on page 5. I don't think we'll make it anywhere this afternoon. I don't think we're gonna finish by noon. Good morning, sir. Mr. Parrish, you were arrested for trafficking in amphetamines, trafficking in ecstasy, possession of a controlled substance, Xanax, possession of ketamine, possession of psychedelic mushrooms, psilocybin mushrooms, it should say, and possession of a place for purposes of trafficking in a controlled substance. Your attorney is present. Good morning. Can you state your name, please?
Good morning, Your Honor. Menachem Mayberg on behalf of Mr. Paris.
Good
So
morning.
he's the third roommate and he wasn't home at the time of the execution of the search warrants.
Okay, Mr. Mayberg, any argument?
Yes, Your Honor, we'd argue for the same reason as yesterday that you find no probable cause on the trafficking amounts. Your Honor, these were personal use. There was a warrant actually that was the reason why the officers came, and nothing in the warrant has anything to do with Mr. Paris. And we'd ask you to find and set the same bail conditions as you said yesterday.
So yesterday was a little different because they found different drugs attributed to each defendant. And I believe the cocaine amount was exactly at the threshold amount. And that's why Your Honor found possession with intent rather than the trafficking.
He's not charged with cocaine here. He's charged
No,
with
he's charged with trafficking in amphetamines and MDMA.
he has a trafficking amount of MDMA. All right, count 1, trafficking. So he has Adderall. And
Yes, Your
MDMA. So 28 grams of Adderall. And then how much MDMA? I don't see a lot. 6
No.
plus 2.
It was
It's 8.
plus the other 2
Uh,
ecstasy.
6 plus 2. I only see 8. All right, count 1, the trafficking in the Adderall. Any traffic in Adderall?
It's amphetamines.
Oh, trafficking in amphetamines. Okay, there's probable cause for that charge. $15,000 bond. Count 2 is possession with intent to sell ecstasy.
Your Honor, I would argue that there's no probable cause for that at all.
Based on the weight. Oh, actually, let me give you a break on that one. Count 2, possession of ecstasy,
Thank you.
MDMA, $2,500 bond. Count 3, there's probable cause for possession of Xanax. Count 4, possession of ketamine. It was he had 2 bags of Xanax pills. It says 20 grams. I don't know the quantity of it.
No, it's not listed there, Your Honor. And we'd ask to fined only for possession.
I did. It's only possession, but I was a lower bond. I'll set count 3 at $1,000. Count 4, he has 2 grams of ketamine. 1 gram of ketamine. I'll do $1,000 count 4 as well. Count 5 is they sell psychedelic mushrooms. It didn't even say psilocybin, ROR.
Thank you, Your
Count
Honor.
6, there's probable cause for possession of a place for purposes of trafficking in a controlled substance. I'll set that, I don't know, $1,000. All right.
Thank you.
No Nebbia. Good luck to you. No Nebbia. He can bond out.
Thank you, Your Honor. Have a good weekend.
It's you better listen to your lawyer. Lawyer, stay in trouble.
Your Honor, what was count 1?
15,000. I'm going to say the bonds again. $15,000 for count 1. Probably really remember. 2,500 count 2, 1,000 count 3, 1,000 count 4, ROR count 5, 1,000 count 6. No Nebbia. Okay.
All right, my friends, we will keep an eye on Judge Glazer. I don't know about you, but it feels to me like she wants to turn her Friday into a Monday, but we'll keep an eye. We'll see how it goes. In the meantime, let's go to Texas. We'll say good morning to Judge Stevens.
Thank you, Judge. Good morning. Good morning, Tom. You don't need to thank me. I sneeze by nature. Nature does me when I sneeze.
He needs to sign it bad.
Oh, my bad. Before. In the states of
No, we won't say good morning to him because he's decided to be muted. Let's move forward a little bit.
or more
We're a
than
little
2
bit
years
back machine with him.
loss.
Judgy.
Number 2
All right,
here. Well,
we'll not go there. Let's go. Let's go to Wexford, Michigan. Judge Elmore.
Maybe a week.
Judge
or so
Elmore
ago
doesn't
for
mute
potential
normally.
resolution. Met with counsel and chambers. They informed me as to what the terms of the pretrial agreement are that they anticipate today. Ms. House, why don't you go ahead and tell me the terms, please?
Thank you, Your Honor. The defendant is currently charged with 1 count of criminal sexual conduct, 2nd degree, pursuant to MCL 750.520 C2.
Okay, friends, I think this is actually
That is
on
a crime that has a
me.
maximum penalty of up to 15 years in prison, requires lifetime sex offender.
I think I missed something in my
registration 4
rebuild.
times
Let's do
per
this.
year, and also
Apologies.
requires lifetime
Let's go
electronic
back
monitoring upon
to
release from prison. As
let's
the
go
court
back
is
to
aware, we
Glazer while I
have
figure out
reached
why my other
agreement,
feeds don't have audio.
between
Hang tight.
counsel.
The charges.
Good morning, sir. You were arrested for battery by a detainee on another detainee. I will appoint the.
Oh, okay. Hearing you in the chat. Thank you. That helps me diagnose. You guys heard audio. I did not. I know exactly what it is then. We're going to hang with Glazer for just a couple minutes while I fix that, and then we'll go to those other courts. Apologies. I had to completely rebuild this show from scratch yesterday, so I figured there would be a bug or two. So thank you for letting me know what you were hearing, because that helps.
He started it. I should have said a higher bond, but I did lower it to 1,000.
De hecho, le iban a fijar una fianza más alta porque él fue el que comenzó, pero se la dejan así.
It's not really clear.
Victim goes into the closet, defendant rushes into the closet, then there's an altercation. He shouldn't have rushed into the closet. $1,000 bond.
We don't know why he was going into the closet, Judge.
Miss Corey, I'm not changing it. That's the bond.
La fianza queda $1,000, no la van a cambiar.
Terrence Collins, page 21.
Had a charge. No, Your Honor, these are regular charges.
He what?
These are regular charges, but he also has added charges coming.
Oh, do you want me to reset it?
He's out of facility. We'd rather just take care of these right now.
So he's not here?
He's here.
Okay.
Okay, problem solved, I believe. Let's go back to Judge Stevens and try this again. Again, apologies for that.
You don't need to thank me. I sneeze By nature tells me what it says.
You need to sign it.
We now call cause number 24. CR 1673, the state of Texas versus Demarion Dwayne Kelly. That's you? Yes, sir. With your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment?
Yes, sir.
And the arraignment here? Can we proceed in a summary?
Yes, sir.
Fine. In summary, this indictment alleges that on or about March 30th of last year, 2024, in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you are charged with here? A state jail felony means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment rate, sir? Yes, sir. Scratches here. An agreement has been reached. Whoa, that was close.
He said it was close, huh?
Yeah, boy, on the restitution, that would have been a 3rd-degree felony for another 1,000 loss. Just come up with number 2 here along with this. Unable to understand the TW. If convicted of a state jail felony, I told you what the punishment range was. And in this case, an agreement has been reached where you would be sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. Most important thing is you got to pay this money back. Whatever happened to the items here? I'm asking you. Where are they?
The person that used me to rent the stuff, they sold it, I guess. And I didn't realize that till later. Saying what was going on.
Oh, so you're not guilty?
I'm not saying that. He's guilty.
I am, but
He worked with us.
Yeah, I am, but it doesn't get it, sir. You're either guilty or not guilty in this room. I'm not guilty, but no, you're either guilty or not guilty. If you're not guilty, we'll have a trial. That's what we'll do and let a jury decide. They don't give probation. No, I just, look, you're hedging. You're hedging. You're charged with theft. You're not going to trick me or try to deceive me. You may try to deceive others here, but no, I've got my hand on my wallet at all times here, keeping it safe. Sir, you're being a smart aleck, is what you're being, sir. I've asked you what happened to this. What I want is the people to be paid back for their loss. If you have the item, I want you to give it back to them, whatever it is you rented.
It's heavy equipment.
Whatever, I'm still unclear. Where did it go? You give it back to them, you don't have to pay restitution.
He said it was sold.
You sold it to somebody?
I didn't sell it. The person that went to jail for it sold it.
There was 2 people involved.
I was used to use my ID to rent the machine, and I didn't realize till later that what I was doing was totally wrong. Uncle, I don't know if Beaumont picked him up or whoever picked him up, but he's currently in jail for it now.
Who?
You want to know his name?
Oh, Jerome Daniel.
Did he get charged?
Yes, sir.
Is that in my court? Jerome Daniel?
Last name is Daniel? Daniel. That's your heart.
I'm not seeing it either.
That don't work, try Jerome Terry Denton. So.
ERRY?
Yes, ma'am.
What does the state have in your file on evidence in this case?
Your Honor, we have the contract from JAC Rentals where this equipment was.
May I see that? What else do you have in there?
An office report, photos of the materials.
Driver's license? Worst thing you can do is attempt to mislead me or stand up here during any process that we handle in this court and make a false statement. That would be the worst thing you could do. And I'm going to find out if you did that or not. Because it's somebody else who used your ID is what you've told me. We'll see, because they say it was you in this affidavit.
Yeah,
It's not a debate. I'm gonna just let me get the information and. What your story is, you had no knowledge that somebody else was going to use your ID and rip this, correct?
Yes, ma'am.
So quite naturally, you got indicted by the grand jury for no reason. Let's see how that plays out. Because the worst thing you can do is get caught in a lie in front of me. What's his bond? Because false statements to this court are crimes.
$5,000. Your Honor, I have the contract with his contact information, but I'm not seeing a copy of his driver's license.
Give me your driver's license.
Oh, it's in the car.
Go get it.
Do you have media?
Yeah, I do have media.
And come right back, or else a warrant will be issued for your arrest. Thank you. I don't know. You might want to talk to him because he's digging a hole.
Let me go outside. Well, he's coming back. You want to keep this case?
Oh, yeah.
Okay.
Yeah, I mean, he's not, I'm not letting him get out of
I didn't see
your side.
I didn't see a driver's license in the discovery, but maybe it is. I don't know. I didn't see it.
I'm seeing name, phone number, email, address, last 4 digits of the credit card.
You heard what he's saying. What do you have to show me to refute what he's saying, that he had nothing to do with this and it was somebody else using his ID? But y'all indicted him. Y'all had an idea of, and the other person was not indicted, correct?
Not in our county.
Yeah, okay. What he's saying is y'all have indicted an innocent man. But that's been said before.
You find it?
What's the picture of it on the far, your deal?
All right, well, I'm certainly going to keep an eye on this, and we're going to come back when he comes back. But in the meantime, Let's go to Florida and we'll do some first appearances with Wade Mercer.
One on the list is Garrett Holton.
Mr. Holton?
Garrett, come on up here. Mr. Holton, good morning. Mr. Holton, you're here because you've been accused of one count of driving while licensed, suspended or revoked first offense. Mr. Holton, there is probable cause for the charge. Your girlfriend is in the courtroom, sir. I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Mr. Holton. He's going to have no contest. The charge is listed. You understanding? He'll be sentenced 10 days in the county jail. He have 1 day jail credit. However, he can be released from jail upon the payment of $400 at the clerk of court and withhold adjudication. He has signed his new form with right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Holton, did you hear that agreement?
Yes, sir.
Now, your girlfriend is in the courtroom, and when I asked her earlier what case she was here on, she obviously told us she was here on your case, and her plan is to try to pay that this morning, because if I was there, that'd be my question. Is that right, ma'am? Okay, so hopefully she's gonna get that paid and get you out of there. So I'll give her some more instructions in just a second. Mr. Holton, I'm gonna accept your plea of no contest to the charge of driving while licensed, suspended or revoked, withhold adjudication of guilt, sentence you to 10 days in jail. But you can purge that sentence at any time before you complete it by paying the court costs and fines set by state and county law. They're $400. So if that purge amount is paid today, you'll be released today. The case is over. You will not come back to court. Mr. Holton and ma'am in the courtroom, but it has to be paid while the clerk's office is open. So here's what I want you to understand. The clerk's office is open 8 a.m. to 4:30 p.m. Since it's a Friday, if you try to pay it at 5 o'clock today, he's going to spend the whole weekend in jail before you get another chance to pay it. So it's got to be paid while the clerk's office is open. They're downstairs. Now, you asked earlier about what manner of payment they will accept. They'll accept, don't help me out, cash or credit card. If they do check the credit card or debit card, there's a surcharge of like 3.5%. You don't have to go get a money order unless you wish to. If you have cash, they do not accept personal checks. Is that all right, Don? Do you have any questions?
No, Your Honor.
Only thing, did you say 5 o'clock? Judge, it's 4 o'clock. They close. So
I thought I said 4 o'clock, 4:30 is what I was meant to say.
Well, they leave.
If you tried to pay it at 5, you won't be able to. They close at 4:30 Central, but if you show up at 4:30 or 4:31, so I'd show up, go ahead and get it done. So if I was in jail, his question is probably the same as mine would be, which is, you feel like you'll be able to get it done this morning? Okay, so she's going to go ahead and take care of it. So here's what's going to happen then. When you make that payment, ma'am, they're going to give you a receipt. You take it, and they will also email the jail and say, this has been paid. You take that receipt to our jail. They're going to process Mr. Holton out. He's done. The jail is on Penn Avenue. So it's back this way towards Interstate 10. There are two interstate exits in Jackson County and Mariana. It's on the western exit. It's on that road, Penn Avenue.
I think I passed it coming through town, trying to find it, but I'll find it.
Yeah, if you put in the Jackson County Correctional Facility on Penn Avenue, it'll come up. And we can give you the address.
Just use that cell phone. Let's Google it. It's right here, just Jackson County Jail.
Just a second, Mr. McDaniel. Miss Williams is talking. I can't hear you. Say it again. Okay. So, ma'am, we have like 6 cases for first appearance. We've got to finish those 6 before Miss Williams can go downstairs to process that payment, just so you know. Okay. So, Mr. McDaniel, you're saying something?
I was just saying, if she just Googles Jackson County Jail, I mean, it'll pop right up. 2737 Pennsylvania Avenue there.
Mr. Ham, would you write that address on there? Yes, sir. Ma'am, do you have any questions? Mr. Holton, any questions?
How long does it typically take after she pays to be released? Is it 30 minutes?
From the time she gets there, half hour probably.
Okay. All right. That's it.
All right.
Thank you.
I think she has one more question, Mr. Holton. You're free to go. Yes, ma'am. Absolutely. Now, where you would pay it at is the clerk's office downstairs on the east side of the courthouse. Okay. Yes, ma'am. The next case that has friends or family here would be Mrs. Odie. Excuse me. Yeah, Miss Odie. Miss Odie will be the next case that has friends or family here. Teresa Zodi. Miss Odie, good morning. Miss Odie, you have a friend in the courtroom on your behalf. He said that you would know who we were talking about. Ma'am, you're here because you've been accused of one count of breach of the peace and one count of resisting an officer without violence. Ma'am, I'm appointing the public defender's office to represent you. I think these are failure to appear warrants. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, we're going to enter a plea of not guilty, enter a plea of guilty, Your Honor, no contest. Understanding she's going to be sentenced to 30 days in the county jail. She have 3 days jail credit, $370 fine. She has waived her plea waiver form, waiving her right to jury trial and call witnesses. You know, as far as the bond revocation, she's telling me that she had to pay her bondsman $7,000, I guess, or whatever. So we're hoping maybe that, you know, I don't know, whatever the court does is what they do. I'm sure the bondsman will ask y'all about it.
Let's see what the status of the bond. Discharge of bond forfeiture. Clerk's discharge of bond forfeiture recorded and filed.
So that one meant that, is this her second time going to agree?
No, first. There's an order of bond forfeiture, and then there's a clerk's discharge of bond forfeiture, September 17th. Letter to judge. See what the letter to judge is. See if that's from Mrs. Odie or from someone else. That was saying she's been admitted to a substance abuse treatment program.
And so, I guess we had originally forfeited the bond, but then we discharged that because I guess it's a letter to your office.
Okay.
Caretaker.
Yeah, I don't. Mr. McDaniel, there's nothing in here showing anything about the agreement with the bondsman. It was a $7,000 total bond that she had. So if she paid a bondsman $7,000, then I don't know what the agreement was with the bondsman. I have no idea.
Your Honor, I paid the bond.
Yes, sir.
I got the bond.
I want to make sure she can hear you. Can you come on up so she can hear you, sir? Because she very well may not be able to if you're not speaking to a microphone. Go ahead, please.
Yes, sir, Your Honor. I paid the bond to bail her out, and then she went into treatment. While she was in treatment, the bail bondsman pressured me to pay the bond and said, she's not there, you got to pay the bond, or I had to pay the bond. So I paid the bondsman the $7,000.
So what was the agreement with the bondsman?
The agreement was standard bail bondsman agreement. I paid 10%, $700 up front.
Right.
I got the bond. Well, when she didn't show up for court, the bondsman didn't care why she didn't show up for court. In fact, prior to her missing the court date, I came down and talked to the district attorney and the clerk of the court trying to say where she was at and provided some documentation. And so I ended up paying the bond. And the bondsman's agent told me, I don't know, 3 or 4 days ago, that when she showed up, turned herself in, that the court would release the bond back to me. I don't know what the correct procedure is, but that's what.
Yeah, they misled you or they misunderstood because there's nothing to release. We don't have anything to release.
So the bail bondsman has the money then, right? Or my $7,000, because
That's what
otherwise
that's
he
what
made.
I thought. When I looked at it, I think he just has the money. I suspect she's turned herself in. He may give it back to you.
He said he would.
Don't.
I know we won't, because we don't have it.
Okay, so the bail bondsman, yeah.
Posted to the bond, and that was your agreement in order for him to sign a bond. And get all-
Right.
Yeah, so it's a contractual question between you and the bondsman that I don't know the answer to.
Okay.
It's
I
going to
have the
depend upon
contract
the
somewhere.
terms of
Yeah.
the contract. Okay.
Okay.
But as far as this case, and I forget where we were at. Did I accept the plea, Mr. McDaniel?
Yes, Your Honor.
And I've imposed the sentence already?
Yes.
Yes, Your Honor.
So, Ms. Doty, you'll finish the 30-day jail sentence. How much credit did she have? I don't think I've
3 days.
imposed a sentence, have I? I haven't imposed a sentence. I'm going to accept the plea of no contest to the charges of breach of the peace and resisting an officer without violence. A judge, Ms. Doty, guilty of those offenses, sentenced her to 30 days in jail. She got credit for 3 days, $370 court costs and fines. And that's based upon the understanding that she did turn herself in. Is that accurate, sir? Okay. So, Ms. Doty, you have 27 days left at most. You may do less than that, ma'am. You may not. That's between you and the jail. But at most, you have 27 days. You may or may not get some additional days off of your sentence. And Ms. Doty, there's no probation involved in this sentence. Ma'am, when you finish this sentence, this case is over. Ms. Doty, do you have any questions?
Yes, I would like to get my caretaker's phone number. I have no way to contact him. I didn't bring my, and even my medication with me. So I'm gonna,
Will you turn yourself in? Why don't you-
I don't know. Because
Okay, so I'm
I
not
didn't
comfortable putting your phone number on
understand.
the internet. We're being broadcast on YouTube right now.
Okay.
So, yeah, so we're not going to do that. But if you want to contact the jail or go by the jail and leave them that information, we can do that. Okay. So he said he'll get it to the jail, Miss Zodi, okay?
Okay, thank you.
All right. Yes, ma'am. Wish you the best. Thank you for coming, sir.
On the fine, does, if I pay the fine, does that reduce or set all your?
It doesn't affect the sentence at all. She'll get a chance to work those off at the jail by doing community service, either inside or outside the jail, and you can't be denied the opportunity to work fines and court costs off because of a physical disability. So even if they'll find something she can do, and if she can't do anything, as long as she follows the jail's rules, she'll be able to work those court costs and fines out, as long as she doesn't get in trouble at the jail.
Okay, so, if I paid the fines now, would that make any difference or?
It doesn't change the sentence at all.
Thank you.
It may prevent her driver's license from getting suspended in the future, because if she doesn't work them off and if she gets in trouble at the jail and she doesn't work them off, then what happens is the clerk of court by law has to suspend her driver's license approximately 90 days after she's released from jail. So I'd wait and see if she got them worked off first. And if she doesn't, then you obviously have the chance of paying then.
If she currently doesn't have a driver's license, she has state ID.
Okay. Any other questions?
No, Your Honor. Thank you.
Thank you for coming. Have a good day, sir. Mr. McDaniel, we have friends or family here on Joshua Morris.
Judge, he's.
Come on up,
I
ma'am.
can go on without him, maybe, hopefully, if you want, if you don't mind. Now, he's, he only has one
I
word
couldn't
to
hear
say.
you. I was talking to her. I was telling her to come up, and I can't hear you when I'm talking to her. So say that again, please.
I try to talk with him in there, and, you know, he only knows one word, and that's mommy. And yeah, so he's in there he's got his shirt off and, you know, crying, saying mommy. So I don't know if I want to rally him up. I'm trying to bring him up.
So
here.
let's see where we stand. So this is State of Florida versus Joshua Morris. Mr. Morris was arrested yesterday and was charged with one count of battery against you, I believe, ma'am. There is probable cause in the complaint. The complaint does contain probable cause. The complaint also reflects Mr. Morris has no criminal history. The complaint says that you're his grandmother. You're Miss Peters, correct? That you're his grandmother. And the complaint also says that Mr. Morris, the language they use is, I don't know if they said he was severely autistic or moderately autistic, developmentally disabled, and they use additional language.
I see low functioning autistic.
Okay, low functioning autistic is what they call it. So is that accurate, ma'am?
Yes.
Okay, so here's, thank you for coming. So I read the complaint, and though he has no prior criminal history, and he's not able to communicate much, if any, with his attorney, Mr. McDaniel. So tell me, what are you suggesting or asking us to do? What do you want us to do with the situation today?
I want him home.
Okay.
I want him home. He can't help it. I mean,
The complaint says that you had injuries to you when law enforcement came, specifically that you had red marks on the side of your face from him scratching you. So my concern is, are you in danger if he comes home?
no, what makes me in danger is his mom. Excuse me, his mama. His mama has done all this stuff to me, and he's been a witness to it.
Okay, so let me try to understand the family dynamic better. Is his mother your daughter? Is his mother's your daughter?
Yeah.
So his mother is your daughter, and obviously he's her daughter. Do you all three live together, or just you, the two of you?
No, it's just me and him, but she has a camper on my property because she's on probation right now. She has nowhere else to go.
Okay.
She's got a very, very bad temper. Her father was that way.
His father,
Her father.
I couldn't understand what you said. Her father what?
Her father was that way.
Was that way?
I ended up in the hospital because of him.
Was what way?
violent
Okay.
and bad temper.
You're not saying her father was autistic. You're saying her father was violent.
Yeah.
Okay.
Yes. And
So go ahead.
she just, if she gets mad, I'm the one who suffers. And if he's in the car, or if he's in the house, or on the property, or wherever we are, then he witnesses it. And that's what's made him this way. He doesn't deserve this.
But you don't feel like telling her to hit the road and getting her off your property is a option that you have?
She claims she's really, really sick. She's got.
Ma'am, that doesn't answer my question. Do you feel like that's not an option?
I would love for her to take that camper and go somewhere else.
If you own the property, you can make that happen. That's up to you to make it happen.
She says that I'm mean because she's sick and I would make her have to leave.
You're the only one that can fix that problem. No one else can fix it but you. So whether you fix it or not, it's up to you. So let me ask you the question then about your grandson. You're wanting him to come home.
I do.
Does he have the ability to understand any special rules that I put in place that might be helpful? I don't mind doing that, but I'm going to make sure he can understand them. And I don't know that he can. You know him a whole lot better than I do.
Yeah.
Are there any rules I could put in place that can he even communicate?
Yeah. Yes. He and I, we've had such a good relationship all these years. He's 18 now, fixing to be 19. And we had such a good relationship. And then when he hit puberty and he would see, her, and he's, because of his problems, I guess he's, or I feel like he's doing what he sees somebody else do, but he doesn't deserve it. We had such a good relationship before. I mean,
Ms. Peters, I can release him back into your custody if that's what you're asking for. My question is there anything else you're asking for other than that?
Well, rules, yeah.
Okay, so what rules can I put in place that he can understand? And then we can talk about trying to get him up in front of me to understand those rules, if that's possible. What rules would help the situation? Because he doesn't drive, is that correct?
No.
So a curfew really wouldn't help because he
doesn't go anywhere.
Are there friends that are bad influences that he needs to stay away from?
No.
Or there's any evidence of intoxicating substances or chemical substances or illegal
he's
substances?
Mentally probably around 7 or 8 years old.
So I don't know of any rules that would help. I don't mind trying, but if there's something that you think might help, I'm glad to talk to him if I can.
Yeah, just tell him, no hitting mama, which I'm mama to him.
Okay.
I'm mommy. No hitting mama, no breaking things.
Those are things you would like to be reinforced to him. Okay, understand those rules.
Yeah.
Those rules you would like reinforced to him, correct?
Yes.
Mr. Mitchell with the state, any questions for Ms. Peters or any input?
John, it may be too early to ask. Well, I can go ahead and ask. You are the victim. Do you see yourself wanting to prosecute him in the future? Okay.
No.
I was about to say that probably makes my
He's
decision
pitiful.
easier.
I mean,
That's a picture of him.
Judge, while I'm waiting on her, I just want to let her know that DCF does have ways that they can assist in these cases, and she needs to contact her DCF and talk to them. Including sometimes other housing options, but they have ways that they have professionals for this kind of stuff to try to help with them, and she needs to contact DCF and let her know the issues so they can try to assist her with these issues. I just don't think it's law enforcement's going to be able to do these things.
That's all the questions I had.
Thank you. Mr. McDaniel, is he capable of coming back in the room so I can kind of stress to him the importance of following her rules?
We're trying to get him a shirt on right now. Let me see where we are. We're trying to I hear him. So
tell him mommy again. Hey, babe. Hey, darling.
Hey.
Mr. Morris, I'm Judge Mercer. Can you hear me okay?
Oh, hey.
Mr. Morris, your mom wants you to come home. today to come back home, but you've got to follow her rules. Do you understand that?
Again,
I couldn't understand. I couldn't hear what he said.
He said, okay.
So, Mr. Morris, it's very important that you follow mama's rules, your mother's rules, and do what she wants to if she's going to take care of you and let you live there. Is that okay?
okay,
Okay. You have any questions?
no,
You're going to get out of jail this morning. She's going to pick you up in a little while then, okay?
okay.
All right. She'll be there in a little while. Come on, Miss.
Mommy, I'm with you. You with you, Mom?
What we're going to do then, let's wait till we get a jailer back in there so they can make notes for their file. Is there another jailer in there to make notes?
Yeah, there is. We got
Okay.
somebody.
So what we're going to do is I'm going to do an ROR to get him out of jail. He's not going to be on conditional release. I don't know that he would really understand those rules. I don't want to burden him more than necessary. Mr. Mitchell, are you wanting me to give him the court date to give you time to get the case in, process it, and take a closer look at it, and then go from there?
Just a tentative court date. I should have my decision made before the January arraignment date.
What would that be?
January 5th. So let me tell you what we're going to do,
I
ma'am.
mean, what does that mean?
Ma'am, listen to me. I'm trying to answer your question. Just be patient, okay? We're going to give you a notice for January 5th. That's his court date, if the case is still pending. So what Mr. Mitchell's going to do is he's going to probably talk to you before then, probably sometime, maybe right after Christmas. If everything's going great and you still want to dismiss the charges, Mr. Mitchell's got authority to do that and cancel the court date. On the other hand, if there's problems between now and then, Mr. Mitchell needs to know that, because that may affect whether, I don't know that you can go forward with this kind of prosecution or not. That's Mr. Mitchell's job, but we're trying to get him to understand the importance of following your rules, and hopefully that will work. If it doesn't work, Mr. Mitchell's got to make a decision. So what I'm going to suggest is that you contact the state attorney's office the week between Christmas and New Year's. Are you working that week, Mr. Mitchell?
Between Christmas and New Year's?
I'm trying to get it before the 5th.
Yeah, I'm working. I should be working.
And let him know how it's going. And if everything's going great, you've heard what he may decide to do. But if he dismisses it now, then if there are problems, then it's dismissed. Does that make sense? Okay. So we're going to give you have a card with you?
Not on me right now.
Okay, will you write the state attorney's office phone number on there on the bottom?
I was going to tell her she can go right across the hall and speak to our victim advocate, Miss McDonald.
Even better. So if you go right across the hall, Sergeant Applewhite will show you where to go, ma'am, and speak to Miss, what's the victim advocate?
Sonia McDonald.
Miss McDonald, and tell her what happened in court. And then you can go to the jail and pick him up. Do you have any questions?
Thank you.
I wish you the best, ma'am. It's a difficult situation, so I wish you the best. Okay, thank you. Sir, are you here for a first appearance case?
This is the type of thing we would discuss on sidebar, quite honestly. Sad situation all around. I don't really know what to say other than I hope she stays safe and he gets the constant care that it would seem that he needs, and somehow it all works out. Let's go back to Judge Stevens. That gentleman is back.
Lois, I'm
issue. So I was at there, I was actually this morning in the first, so entirely different. But the kids all the change that. If it's a problem, so it's actually excited. So those are the signs and then. The conference check to prevention. You get the media on down here, how on the back.
Huh?
Guys, let's look at it this way. We're already outside of 10 days. Let's look at it and see if we can get it in on the whole thing. The presence and impression of saying. Wait a few moments. So. That is really good.
Yeah, they've got, this is the same one they have a copy of. They use those. This was your ID that the state had it. That's the same one. That's you.
I just don't like that. We're trying to check on the media, Judge, see if there's any videos of the transaction. Give us a minute. App. So we got, I didn't mind.
She has a copy of his ID already.
Oh,
they have a copy of it.
It was in the box?
Yes, it's
It's the same. It's the same
in the
ID
discovery,
that
and it's
was used, and that's the one that was
the
used.
driver's license.
He was in there. That was him
as well.
Not somebody else. That was him.
Are you accepting responsibility?
Yes, I was just letting them know that I was That's all.
No, you were letting me know you weren't guilty of this crime. It was somebody else's fault. You didn't know what was going on. That's what you, I'm
You
sorry.
gotta accept responsibility.
Did you do it or not, sir? Did you go in there and
Yes.
rent this thing?
Yes, I will.
So why would you have said otherwise to me? Why would you have said it was somebody else? My goodness. First thing to fix any mess is to be honest about it. Don't compound the problem. All you did was throw gas on a fire that he's trying to put out.
Yeah.
Yeah.
See where the one is.
The agreement that has been reached here is that you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $29,000. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty? I didn't hear. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked here as States Exhibit 1. You just sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
That's your signature is what he's asking.
No.
Yes.
Is everything true and correct, Will?
Yes.
States Exhibit 1 is tendered into evidence.
No.
Without objection. And
Here's.
among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and your indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination, and witnesses. You were totally satisfied that the representation provided by your lawyer, all of this is true, so help you God. States Exhibit 1 is moved into evidence without objection.
No objection.
It is granted and allowed and admitted. Pre-sentence report is hereby waived.
Yes, yes, sir. That we
If nothing further to add, I'm going to follow this agreement. I'm going to find Mr. Kelly, you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I am following this agreement. I find you guilty beyond a reasonable doubt of the state jail felony. You are hereby sentenced to confinement in the state jail for 2 years. That term of confinement is suspended. You were placed on regular probation for 5 years. There will be terms and conditions of probation which you must follow. Failure to follow these can result in revocation of your probation, and you can be placed into the state jail up to 2 years. The most important term, the two important terms, don't commit any more crimes. Number one. Number two, pay these people back. You must pay $29,000. How are you going to do that? Do you have a job now?
Yes, sir.
What do you do?
Warehouse ops.
Okay. How much do you make an hour there? I'm sorry?
$15.
That's about $30,000. Do you have a family at home, or is it just you that you take care of?
This means.
Okay. How much are you able to pay per month toward this restitution? This $29,000. That's not going to happen overnight. What can you pay per month? Okay.
Gotcha.
You know how long that would take? 23 years. Is that how long you want to be on probation? You have to speak up. She can't put a nod or a shaking of the head. No, you have to speak up. We got to communicate here. Is $100 the most you can do?
200.
Can you? No. Don't put more than you can. Don't stick your neck. If you fail to pay in this, you made a mess. You're trying to fix it. Don't make it worse. What's realistic? 200? 200 is realistic. That's still, that's 2,400 a year.
Yeah.
And at 29, that's still 10 years or 12 years.
That's a cool.
It's a start. All right, what else? Anything else from the parties?
Nothing from the state, Your Honor.
All right, please see this lady. She's going to go over all the terms and conditions of probation. You will begin probation. Thank you.
Right here.
Okay, let's slide over to Judge Elmore's court. I tried to go there a little bit earlier when I had the audio snafu. Let's give that a go again.
I think we were last on the record maybe a week or so ago for a potential resolution. I met with counsel and chambers. They informed me as to what the terms of the pretrial agreement are that they anticipate today. Ms. House, why don't you go ahead and tell me the terms, please?
Your Honor, the defendant is currently charged with one count of criminal sexual conduct second degree pursuant to MCL 750.520 C2B. That is a crime that has a maximum penalty of up to 15 years in prison, requires lifetime sex offender registration 4 times per year, and also requires lifetime electronic monitoring upon release from prison. As the court is aware, we had reached a plea agreement between counsel that we had presented to the court that the court was not comfortable with. But just for the record, that plea agreement was that the defendant was going to give a factual basis to the CSD second charge. And then we were asking that the court enter a conviction for assault with intent to commit penetration, which carries a 10-year maximum penalty. We had reached with that a plea agreement that the defendant would be sentenced to 38 months to 10 years in prison on that prior plea agreement. The court expressed clear concern with doing a plea agreement of that nature where someone's admitting to facts of an offense that is not the offense that the conviction enters for. The court made clear that they would not accept that plea agreement. The court did make clear that they would accept a plea agreement to an attempted CSD second with that same minimum guideline. And so I want to make that clear because the minimum guideline of 38 months in prison, the maximum would then be 5 years or 60 months in prison. That is within the allowable guideline that a court can sentence to up to 2/3 of the maximum penalty. But I do want to be clear that 38 months is outside the minimum guideline range for attempted CSD second. So as I have scored the guidelines, if the defendant had been convicted of straight CSD second at trial, his guidelines would have been 36 to 71 months as a minimum. For an attempted CSD second, I score his guidelines as 7 to 23 months as a minimum. So I want to be clear that as part of this plea agreement, we are now offering that he can plead guilty to attempted CSD second, but the sentence agreement for the minimum remains the same, which is 38 months in prison with a maximum of 5 years or 60 months. And that we are all agreeing right now that we recognize that 38 months is above that minimum and that the court has good reason to accept this plea, but also to exceed those guidelines, and that the defendant is agreeing to that at this point and is not going to be objecting later by saying, well, that was outside the scope or above the scope of the scored minimum guidelines. I also want to be clear for this plea agreement. I had said that if he had been convicted at trial of CSD second, he would be subject to lifetime electronic monitoring. A significant benefit that he gets from the sentence is not only the reduction of his maximum from 15 years to 5 years, but also that there is no lifetime electronic monitoring for attempted CSD second, but the sex offender registration will remain the same. He will register for the rest of his life 4 times a year as a sex offender based on this agreement. So it's my understanding he'll be pleading guilty today to attempted CSD second with that agreement that he serves 38 to 60 months in prison, with the understanding that that is above the scored minimum guidelines, and with the understanding that he will register as a sex offender quarterly for the rest of his life. And in exchange for that, the people will dismiss count 1, the CSD second charge.
All right, thank you very much. Mr. Champion, is that a complete accurate statement of the trial agreement?
It is, Your Honor, and my client's aware of it. Again, I would emphasize that he would not be required to lifetime electronic monitoring.
All right, thank you very much. All right, Mr. Birch, have you heard what the attorneys have described to me today as the pretrial agreement in this case?
Yes, sir.
And is that how you wish to resolve it, sir? To the best that you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. Birch, I'm going to go over the terms of this agreement with you in just a moment. Again, we're not arguing any further, but I'm just saying, yep, I do recall our conversation here on the record a week or two ago. I also went back and continued to do other research, spoke to several other judges who shared a lot of my concern, and some of the other cases that I had read that talked about interpreting the court rule that we talked about, which was Court Rule 6.302. A lot of those cases actually were where somebody was appealing the wanted to withdraw the plea. The court stood by the plea because when it was entered and then accepted by the court, it was based upon the agreement of the parties. So a little bit, somewhat similar or dissimilar situation, but I stood by Judge Viviano's dissent. Now, in this particular case, we're going to talk about this agreement here right now. Currently, you are charged on a piece of paper called the felony information. That charges you with a single count. That single count is criminal sexual conduct in the second degree upon a person under the age of 13, where the defendant, you, were 17 years of age or older. An act of criminal sexual conduct in the second degree is an act of sexual contact. In other words, touching certain parts of a body under or over clothing. Now that is a felony punishable by up to 15 years. And as you heard Ms. House cover, lifetime electronic monitoring upon parole and mandatory AIDS and STD testing, DNA taken upon arrest. Plus, there would be requirement to register as a sex offender under Tier 3, which is the most severe in the state of Michigan, which is a registration for the remainder of life with up to quarterly reporting. Now that charge is going to be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be attempt to commit criminal sexual conduct in the second degree. Same thing, under a person under the age of 13, where you were 17 years of age or older. Now, when it's an attempt, it does a couple things. For instance, there are what's called the Michigan Sentencing Guidelines. And you've heard a little bit of talk about that already, and I trust that Mr. Champion's talked to you about it. Now, there are different classes. For instance, we have classes A through H. Well, when it goes down to an attempt, it changes grids and goes down to a less serious grid. We're going to talk about that in just a moment too. But anyways, a plea to attempted criminal sexual conduct, or conduct in the second degree, would be still a misdemeanor. I'm sorry, felony. Sorry, thank you. I don't know where that came from. Forgive me. I got a lot of stuff going on here today, but it is still a felony, and it's punishable by a maximum of up to 5 years, plus registration underneath the Sex Offender Registration Act as a Tier 3, which is still the same. It's for life and requires quarterly reporting. There is, however, not the requirement to have lifetime electronic monitoring. Now, when I talked to you about the Michigan Sentencing Guidelines, I told you that there are these grids, and what Ms. House is telling me, which Mr. Champion, as I understand, agrees with. Those grids give the court a suggestion as to what an appropriate sentence would be. And I'm told, for example, that if you were convicted of criminal sexual conduct in the second degree as charged, they estimate that your guideline range, the minimum end, would recommend to me a sentence somewhere between 36 and 71 months. They are also telling me that, at least in their estimation of the guidelines, if you plead guilty and I accept the plea to an attempt CSC 2, it would be a 7 to 23 range. Now, that's really important because the agreement today is that you're going to allow me to exceed those guidelines. Now, the Michigan sentencing guidelines are not mandatory upon a court. They are, however, a tool that we are required as judges to use in establishing a sentence. However, the court can deviate from those guidelines in some circumstances. And I would have to give justifications on the record for doing so. What I'm told here is that the parties are already, this includes you, agreeing that I will be able to deviate from the guidelines and go and give a minimum of 38 months. Right? And that means the maximum would be up to the 5 years, or in other words, 60 months. You heard Ms. House talk about this 2/3 rule. There is a statute here in Michigan that says whatever the maximum is, a court cannot give more than 2/3 of that maximum. Well, this 38 months obviously is within that or below that 2/3 maximum. So I think it would still be a legal sentence, especially if the defense is agreeing to it. Do you understand so far? Okay. Now, when I ask you questions, I'm not offended at all. Don't worry, you didn't do anything wrong. When I ask you, make sure you say yes, no, and give me words, only because Nancy has to take words down. Okay?
Okay.
All right. Did you understand everything I said?
Yes.
Do you have any questions about what I said thus far?
No, sir.
Okay. Now, Mr. Champion handed to me before we began this morning a piece of paper that at the top says advice of rights, and at the bottom appears to have your signature. Is that your signature?
Yes, sir.
Now, did you read through these rights before signing?
Yes, sir.
And did you understand what you read?
Yes, sir.
And you understand that by pleading guilty, again, if I accept that plea, you will be waiving these rights?
Yes, sir.
Now, because of the nature of this offense, I want to make sure that even though I've got that signed advice of rights, that you and I talk about it. If you enter a plea of guilty and I accept that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at the trial if you chose to testify. Mr. Birch, do you understand all those?
Yes, I do.
Do you have any question about them?
Yes, sir.
And again, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights?
Yes, sir.
Additionally, any appeal that you would have pursuant to the plea and the sentence, which is based upon this pretrial agreement, you couldn't file what's called a claim of right to appeal. That means that the Court of Appeal has to look at it, has to entertain it. You only get a claim of right if you've been convicted at a trial. Because it's going to be a plea and a sentence, any appeal would be done by filing a different process called an application for leave to appeal. Furthermore, you may be given up the right to appeal issues but only otherwise be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today. So what I need to do is make sure that you're making this choice of your own free will. Are you?
Yes, sir.
Have there been, other than the terms that I've already talked about, have there been any other promises, threats, coercion, duress, or terms of the agreement that we haven't discussed? Okay. Now, again, I know we've already talked about this potential sentencing. Now, I've already expressed my intent to comply with the agreement, okay? Let me explain this. I'm very cautious because if I do this, then it looks like I'm breaking a policy. And I like to state it on the record so no one brings it back up to me. There are different ways to enter a pretrial agreement with the prosecution and the defense. So I like to tell people, imagine there is a triangle, agreement to there, and then to me, and then back to you. That's called a Cobb's agreement. I generally don't do Cobb's agreements. Cobb's agreement, that name just comes from an appellate case. It says the court can agree right now as to exactly what the sentence is. I don't do those. I don't do them because I don't know anything about a defendant. Now, in this particular case, I've already agreed that I'm going to go along with the agreement. I'm just kind of covering my tail because I don't want anybody else to come in here and say, oh, Judge, you changed your policy. No. But these counsel and I have talked extensively about the case, and I understand why we're going to here. The other kind of agreement is a line between you and the prosecutor. That's where it's called a Killebrew agreement. That's where you all reach an agreement. And if I don't go along with that sentencing, you would have the right to withdraw your plea, come back to the stage of the proceedings. So I do have to ask one small question here of the counsel. Is this an agreement that the minimum will be 38 months, or is it a minimum, or is it an agreement that that's the lowest I can go? Because that tells me whether or not I'm agreeing to a Cobb's or a Killebrew, and whether or not I go above or below that. I'm sorry, above it.
The offer has been that that would be this.
Okay, I just want to make sure. Now, the reason that question is important is because it tells me we are not doing a Killebrew agreement. We're really kind of doing a Cobb's agreement, because I'm trying to provide everybody some security and sense of understanding. And that also tells you that when the prosecution comes and we have victim impact statements, I'm not going to go above the 38. That makes sense? Yeah. If we have the Killebrew agreement, like I talked about, which is the line between you and just the prosecutor, they could come in, they could argue, and I'd listen to victim impact statements, and it could go up as long as I didn't pass the 2/3, of course. And by the way, it's not a whole lot further. It's only a couple months, but anyways. So I'm telling you that in effect, this is a rarity for me. In other words, I'm agreeing to the sentence now. Now, for some reason, I don't go along with it, which I can't imagine. I could try to withdraw from it. The only way that would happen is if I somehow find out that your criminal history record is a lot longer, that you are wearing a mask and you're really a assassin wanted from all over the world, right? But as long as everything's the way they're telling me, I'm going to go along with it. Do you understand?
Yes, sir.
All right, great. And you have any questions about what we've talked about?
Yes, sir.
Now, I'm about to turn next to the step where I ask you what your plea is, and then I have to ask you to tell me what it is that you did that makes you guilty of this offense. Before I do so, do you have any questions at all that you need to ask Mr. Champion?
No.
And you've had enough time to speak with him about this plea?
Yes, sir.
All right, good enough. Thank you. Mr. Birch, as to the added count 2, attempted criminal sexual conduct in the 2nd degree, how do you plead?
Guilty.
Now, before the court accepts that plea, I'm going to need you to tell me what you did that makes you guilty of that offense. So before we do that, I'm going to start, or as we do that, I'm going to start to ask some questions. Just going to ask.
You need to be sworn in.
Yeah. Can I swear him in?
Maybe he didn't. I missed it.
Yeah, I
Sorry,
did.
it was so long ago. I apologize.
It's okay.
Trying to cover all our
Are you
bases.
trying to say I talk too much?
No,
It's okay.
I didn't. I definitely was not saying that. I just want to cover all our bases, and you did that early, and then we did other things.
I don't worry about it. I'm just trying to keep the atmosphere light. Thank you. All right, Mr. Birch, I'm going to turn your attention back to a date. It's about a little over 10 years ago. Back to June 2nd, 2015. Back here in the city of Cadillac in Wexford County here in the state of Michigan. What did you do? Where were you living at that time?
I was living at 1012 6th Street in a camper.
Okay, was that in 6th Street? Was that here in Cadillac?
Yes.
Okay, and were you living there with anyone else?
I was actually just there to visit. It was my daughter's parent, or my daughter's mom.
Okay.
And her family.
Okay, and what happened? There was some young girl there.
Yeah.
Tell me what happened. Who was she?
That was my stepdaughter at the time.
And what was her name?
Marcia.
Okay, your stepdaughter was Marcia?
Mm-hmm.
Okay, and how old was Marcia at the time?
11.
So she was under the age of 13?
Yeah.
And you knew that, is that right?
Yes, sir.
All right, and so what happened between you and this stepdaughter, Marcia, that was some kind of sexual contact upon her? Tell me about that.
We were sleeping in the camper and I was humping her.
Humping, right. Now this is one of those things that's kind of difficult, and I want you to know I'm going to help walk you through this. When someone uses the word humping, it might be easy to say, yeah, we probably have an idea of what that means. But once you tell me, I'm going to ask you some questions. Were the two of you laying in the same bed in this camper?
Yes.
And was she asleep or was she awake?
Asleep.
And was she clothed or unclothed?
Clothed.
And were you clothed or unclothed?
Clothed.
And were you under blankets or over blankets? Tell me about that. Do you know?
Don't recall.
Okay. And so how were the two of you laying? Were you side by side, rolled on your side? Give me an idea.
We're on our side.
On our sides? Okay. Were you in front or behind her?
Behind.
All right. And then so did you pull her body close to yours or yours close to her?
Yes.
Okay. And when you said humping, what part of your body was touching her?
My penis.
All right. So your groin area was touching what part of her?
Her butt.
Okay. And you knew this was happening?
Yes.
All right. And was she awake or asleep?
Asleep.
Did she wake up at all during it?
Yeah.
Okay. And when you say humping, do you mean you were rubbing up your private area against her private area?
Yes.
Okay. And when she awoke, what did she say or do?
She told me she was cold and she wanted to go in the house, so she went in the house.
Okay. Were the two of you the only two people staying in this camper on that night? No? Who else was present in that camper?
A friend of mine, Michael Yarbrough.
Okay, but was he in the same bed or a different bed?
Bed across.
All right, thank you. And when you were doing this humping motion, was it for some sexual purpose for you? Were you doing it for a sexual purpose?
Yes.
All right, and so was that because you had some sexual desire that caused you to do it, and that's why you were rubbing up against her?
Yes.
Okay, thank you. All right, Ms. House, do you believe the defendant has provided a factual basis to support the plea to the add count two?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Mr. 6.302?
I do, Your Honor.
Thank you. Mr. Champion, do you agree with all three?
All three, Your Honor.
Thank you very much. All right, this court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. I further find that the testimony provided by the defendant under oath on the record satisfies the elements, not only for the greater offense, but allows the court to accept the lesser included offense, which is added count two. Therefore, the defendant is found guilty of added count two. Mr. Birch, that means we'll now have to set the case for sentencing. Sentencing typically takes place in about 4 weeks. However, because of the holidays, sometimes it might take a bit longer. Between now and then, a Michigan Department of Corrections officer, also known as a probation and parole officer, is going to prepare a pre-sentence investigation report. This report will include a description of the agreement, description of the facts, what happened. Tell us about the pre-trial agreement. It will also include information that you provide while the report's being made. And it will include a scoring of the guidelines. Remember, guidelines likely, which are an estimate, may be between 7 and 23 months. We've made an agreement today that the minimum end is going to be the 36 months. I also want you to keep in mind that it's going to have a recommendation. That recommendation comes from that probation or parole officer. I highly suspect that it'll be consistent with the pretrial agreement. But the key point here is whatever it says, it's the court, me, who determines the sentence. And in this particular instance, it's going to be consistent with the facts and the details that we've talked about today. Do you understand?
Yes, sir.
Now, there are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet. The clerk has just handed it to the bailiff. He'll give it to you when you leave here. You'll open it up, follow the instructions, and turn it back in. You'll also be subject to an interview with an agent from that department, and you have the right to have your attorney present during that interview. Also, Mr. Champ is going to come by back and visit you and go over that report. He generally gets a copy of it somewhere between 10 days, maybe 2 weeks before we come back. Now, it's important that the two of you go over to make sure that it's complete and accurate, as I'm going to base the sentence on it, but also consistent with our pretrial agreement today. Each side has the right to come to the court and request corrections or make objections to the contents of the report. Also, when we come back for sentencing, you may receive when we get that report back, there might be a victim impact statement. However, I remind you also that a victim, which can include the young girl, who I now understand is obviously also a small point. We forgot this point. Mr. Burke, how old are you at the time? How old are you right now?
I'm 33.
And at the time, therefore,
34, sorry.
I'm sorry?
I'm 34.
All right, so back at the time, you were 17 years of age or older, at least, it sounds like.
I was 23.
23, 24, all right. The court reaffirms its finding as to guilt as to count 2. Thank you. We may hear from the victim. We also, dependent upon her age, I don't remember what it is. I don't even know right now. We might hear even from a parent. Okay. You have any questions about what we have done today, Mr. Birch?
No, sir.
Do you have any questions about what's going to happen next?
No, sir.
All right, thank you. Mr. Champion, anything further?
Nothing further, Your Honor. Thank you.
Court revokes bond. I'm required to. And therefore, anything further, Miss Hunt?
No, Your Honor, thank you very much.
Thank you very much. We are adjourned.
38 months, not 36, correct?
Correct.
38.
Thank you.
Sorry, if I said 36, I apologize. Thank you very much, Karen.
Okay, just to clarify, because we had some questions in the chat about what Judge was saying with regards to 2/3 the maximum. So I looked it up, and I thought that Michigan had this, but I wanted to make sure that I had clarity on it to share with you. This is called Michigan's 2/3 rule, but we either misheard what he was saying or he misspoke. So what the 2/3 rule means is that for the minimum, the judge cannot exceed 2/3 of the maximum sentence. So, for example, let's say the maximum sentence for a particular crime is 15 years. 2/3 of that would be 10 years. So if he sentences in a range, the best he could do, the worst he could do, rather, would be 10 to 15 years. He couldn't go like 12 to 15 or 13 to 15. It's that minimum portion which can't exceed 2/3 of whatever the maximum for that crime is. So hopefully that makes sense and help clears it up, because it wasn't necessarily making a whole lot of sense prior to that. Let's go. Let's I'm in the Wayback Machine with Judge Stevens. I kind of want to go there, but he deletes things. So, and he's ended his stream. So I don't know if we'd get the whole thing. Let's go to Judge Middleton. I think it's like a bond violation or probation violation. It's a bond violation hearing. Let's check that out.
This is Judge Middleton. You got arrested last night for an alleged violation of your bond. Also with us here on the feed is Paul Gibson. He is filling in for the public defender. He came on short notice. I saw when I came in this morning that you'd been arrested and Bell got arrested.
Yes, sir.
Let's start from the beginning. You're charged in file number 252254FY with assault with a dangerous weapon. It's alleged that you tried to assault or did assault your partner, Bell Ghost, with a shovel. You got arrested and the bond was set in the amount of $15,000 cash or surety, which you posted. One of the conditions of your bond was that you were not to have any contact with Bell. According to the bond violation report, the police executed a search warrant at this house because of zoning issues, 700 Hoffman Street. Is that the big old house with the old Jacobs house?
No, Your Honor, it's not. And she had just showed up literally right when that had started happening. She actually would testify for me on my behalf. She said that she had just showed up.
Well, who lives at that house?
It's not a house, it's a property, and there's tents and
all right, so yeah, people have started to camp out back there.
Yeah.
At any rate, you guys were a mess. I don't want to go too much into it, but they found you in a camper in not good circumstances, drugs, and they arrested you for violating your bond condition. They arrested Bell for a violation of Judge Stutzman's order. She also has a warrant out for her from Battle Creek. So now you're not supposed to have any contact with each other and you're both in the jail. You and Bell are not in the same cell, are you?
Yeah, we are.
Oh, you're in the same cell?
Yes, sir.
Oh, boy. The matter is set for a pre-exam conference with Rhonda Ives. For December 9th. There was some sort of a camper there?
Yes, sir.
Is that where you were staying?
Yes, sir.
Is it hooked up to electricity or anything?
No, sir.
All right, well, the clear condition was you weren't still having any contact. And you were both there in the same camper and the allegations were not the best. I wish the hearing were sooner. You're essentially homeless and so is she. Now she's in jail and you're in jail and you're in the same cell. How crazy is that? You're not supposed to have any contact with each other. Mr. Gibson, do you have any input on this?
I guess not right now. Is she it sounds like she's asking, like she's disputing that she violated the bond condition.
Well, like I said, Belle said she would testify for me that she had just showed up, like right when the officers had showed up. She wasn't there previously to that.
My original thought was I was just going to leave you in jail until December 9th. You seem pretty good this morning, but I don't want a housing issue for the jail, and I got both of you in the same cell. The place is not good. You're a trespasser on there. Who owns this camper?
I do.
Well, you got to get it off of there. Have you got someplace to put it?
Yeah. Yeah, I could take it to Jeff Brown's.
Well, he's not doing well, but he did tell me that you're welcome at his place.
Yeah.
I asked him about that. He said, no, she's welcome to be here.
Yeah.
This is a strange circumstance. You're charged with an assault with a shovel. And from the report, Bell didn't want to cooperate with it in the first place. That's not the problem. The problem is methamphetamine or opioids. I'm gonna find bond violation and give you 1 day credit 1 day. I don't want you and Bell sitting there in the same cell. You're gonna get out of jail. I also don't want you to forfeit your $15,000 cash or surety bond. You can't have contact with each other. She's gonna be in jail for a while. Judge Stutzman's got a hold on her and so does Calhoun County. But I'm not accomplishing much if I got you guys in the same cell. You didn't really do anything, but you got to get your stuff out of there. Also, if I leave you in jail, they're going to haul all your stuff out of there and take it to the dump or something. You need to get out, get that property out of there. You're going to lose all of it.
Yes, sir.
All right, Ms. Ghost, your next hearing is set for December 9th. Bell, are you acceptable with me making a finding that excuse me, Mandy, that you had contact with Bell in violation of the condition of your bond?
I'm sorry, what was that?
Are you acceptable with me making a finding that you violated your bond by being in that camper with Bell?
I mean, yeah, sure, I guess,
All
yeah.
right, and I guess the offer was I'm gonna let you out of jail, but I don't want you sitting there in the same cell, and I don't want an administrative headache for the jail to figure out what to do with both of you. So I'm letting you out. I want you to go back there, get your stuff and get out of there before the
Yes, sir.
city takes it to the dump.
Yes, sir.
All right. Good luck to you.
Can I just add one thing, Your Honor? I also know that Mandy Allen is scheduled for a status conference in circuit court on Monday, December 8th at 9:30. So she should make a note of that.
They didn't cancel it? They added to it.
Yeah.
All right, you got that, Mandy?
Yes, sir.
All right, you got one hearing Monday and one hearing Tuesday.
Thank you.
Those pants are kind of droopy. They need better lady pants for the jail. All right, you're good to go.
Thank you.
Put those green jumpsuits on.
Better lady pants. Okay, wherever you are right now, I want you to pause what you're doing and just do this with me. Just repeat after me. Ready? Shovels and meth in a tent. Oh my. 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 You're welcome. That's now stuck in your head for the rest of the day. Congratulations. I told you we were going to have fun today. As far as them being in the exact same cell, that is that little known, seldom used Michigan Mutual Compact Gladiator rule, where they basically just set them up for a cage match. And, you know, whoever wins, wins. All right. Let's check in on Glazer. Yeah, let's do that.
Alon's Fuentes. The Wolf is here. Mr. Wolf is there? I'm sorry, who is this? Fuentes. Good morning, sir. You were arrested for burglary to an occupied dwelling and grand theft. I will appoint the public defender's office for you. See what's going on. It's from November 6th. Residential burglary, and it looks like over $8,100 in currency was stolen from the victim. So I guess, let's see. So he's the friend of the victim, and he's the only other person who knew where the money was stored. Okay, I believe there's probable cause for the charge of burglary to the occupied. Is it occupied by a person? I mean, he said he heard him trying to enter.
He was unoccupied.
rates. You're ordered to stay away from the alleged victim whose initials are MS. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Count 1, burglary to the unoccupied dwelling, $7,500 bond. Count 2, grand theft is $2,500. Have a nice day. Next is Eduardo Yasel, page 9.
Call for immigration.
Okay. Did you want Mr. Wolf? He's here. I'll take Mr. Wolf's case, sure. That first calling. I'm sorry. I don't know what to do with the paperwork. Good morning, Mr. Wolf. You were arrested for criminal mischief, $1,000 or damage, battery, and petty theft. I will appoint the public defender's office for you. I believe there is probable cause for the charges. It says that there's $2,000 damage. That's what they cost or valued at the 2 credit card processing machines. You are ordered to stay away from Saeed Ismail, the alleged victim. No contact with him either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Stay away from the 7-Eleven at 350 Lincoln Road in Miami Beach, Florida. Count 1, criminal mischief. I'll set it at $2,000. Count 2, battery, $1,000. Count 3, petty theft is $150. Have a nice day. Next, Eduardo SL. Page 9.
Your Honor, he held under an AC, no bond, and he also has a hold for immigration.
Oh, last, who's the one that had it? Hold on, the one that had it? No, I don't remember. Oh, no, that was when I passed, sorry. I passed Cleveland Ennis, did I? I don't know. Eduardo Yasel, good morning, sir. You were arrested for possession of cocaine and possession of paraphernalia.
Spanish?
No.
Español?
Spanish. Sir, you were arrested for possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you.
Buenas tardes, enfrento el cargo de tenencia de cocaína y tenencia de parafernalia para drogas. Le asigno el abogado de oficio para que lo represente.
All right, you're out on bond. You have a hold to see the division judge Monday for case F25-21210.
También tengo una orden de retención por un delito mayor del caso F25 que termina en 1-0. Verá a la juez o el juez de esta división el lunes.
You also have an immigration hold.
También tiene una orden de retención migratoria.
His office is appointed for you.
Y le asigno al abogado de oficio para que lo represente.
All right, count 1, the bond is $1,000. Count 2 is $500. Have a nice day.
Para el primer cargo, la fianza son $1,000. Para el segundo, 500. Pase un buen día.
Anthony Streakin, page 9.
She seems calm. She must have had lunch or a break or something. You know, something. Let's go to Lake County, Ohio. Judge Collada. Interestingly enough, that court, and I'm not going to play it this way because there's no way I'd ever encode it without crashing the system, but that court actually broadcasts in 4K. Crazy, man.
Today on State versus Diane Tinkersley, file 24 CR 1474. We're here today for sentencing. At the last hearing on June 9th, we were supposed to have her sentenced. She failed to appear. It's the state's understanding that the PSR has not been completed, which would lead only to a prison term being imposed in the state of Ohio. I would ask you to impose it. Thank you.
Thank you. Tom, is there any reason not to go forward with sentencing?
Your Honor, Ms. Tankersley would like to request that the court to give her time to complete the pre-sentence report. I understand that she did fail to appear back in June. Your Honor, I did try to contact her. We were never able to touch base, so she would just like to ask the court.
Why would I do that? She was told if she didn't show up that I couldn't consider probation, and I wasn't going to consider it, delay the sentencing any further because she decided not to show up. She's been through this plenty of times. Why? I don't get why I should do that. You made a choice. You made a decision. You chose not to show up. So that request is denied.
Okay, thank you, Your Honor. With that being denied, we would be prepared to proceed with sentencing.
All right, is there anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would just like to ask the court for the minimum prison sentence today. Your Honor, prior to all of this, I had many conversations with Ms. Tankersley. She did have every intention on completing it, so I don't fully know her circumstances of not completing the pre-sentence report, but prior to all this, Your Honor, she was trying to get her life on track. She was attending school. She's still attending school. She does have 2 years left on that. So, Your Honor, we would just like to ask the court for the minimum sentence today. Thank you.
Thank you. Tankersley, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Practice him.
Whatever you're comfortable doing.
I would just like to apologize for not showing up for court. However, I was with the flu.
That was 6 months ago.
Yeah. I had the flu.
For 6 months?
No, not for 6 months, but when
Does that
the
prevent
court
you?
date.
Did that prevent you from picking up a phone and dialing a phone number?
I did call Nicolette a couple of times.
No, I'm talking about back in May when you weren't supposed to, when you didn't show up and you couldn't make it because supposedly your ride wasn't available. Did you call probation and tell them that?
No, I did not.
Well, go ahead.
But I apologize for not showing up for court or calling probation. I don't know. I'm sorry.
Thank you. Ms. Thomas, is there anything else?
No, Your Honor. Thank you.
Gregors for the state of Ohio.
Thank you, Your Honor. The state of Ohio understands that the lack of a PSR in this matter, this court's unable to hand down a sentence for community control sanctions. We just ask that you give her an appropriate sentence. Thank you.
Thank you. Attorney Desmond, how much credit is there in this case?
4 days, Your Honor.
1 day originally and then 3 since she's been arrested? This court has considered particular facts and circumstances of the offenses involved, the nature of those offenses. I did order a pre-sentence report and investigation. However, the defendant failed to appear at the probation department for her interview, so that was not able to be completed, so I don't have that to consider. Though I have considered the defendant's prior criminal history, as that has been provided to me. Consider what's been said here in court. All this is considering the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. So the recidivism factors, almost all of these are present. The defendant has an extensive criminal history. She's previously served multiple prison terms. She's been on probation before. To me in the past, has violated her probation multiple times. So she has not complied with previously imposed sanctions ordered by courts. It's a drug abuse problem that relates to the offense, and she's not getting help for it, and not even doing what she needs to do to put herself in a position to try to get help for that. She claimed that after she pled and she went to the probation department for the initial referral, that since this incident happened, she's been making the effort to change her life around. Yet you showed up, tested positive for drugs, so I'm not sure what effort was made there. No genuine remorse. She violated conditions of her bond again in using drugs while on bond and failing to show up for court. She didn't appear for her sentencing hearing.
I apologize. I'm on call, Your Honor.
Well, that doesn't matter. When you're in court, that doesn't excuse that.
No, I understand.
No factors indicating recidivism is less likely. Under 29-13B1, court finds the defendant previously served a prison term. Further, that there was no pre-sentence report able to be completed because of her not showing up when she was supposed to. Therefore, the court doesn't even have the authority to impose community control. Prisons consistent with the purposes and principles of sentencing. And the defendant's not amenable to any available community control sanctions. Previously, this court has sent Ms. Tinkersley to prison on a couple of occasions. And there were significant stints in prison. That didn't seem to affect Ms. Tinkersley at all. She gets out and she continues the same behavior. I mean, the last time she went to prison in 2020, it was a 3-year sentence. She got out and started the same conduct. She's a drug trafficker. Minimum sentence certainly is not warranted here. As the sentence of this court finding that the prison is consistent, the defendant is not amenable to community control sanctions, that on count 1, the defendant served a term in prison of 11 months. On count 4, she served a term in prison of 17 months, as we served consecutive to each other for 28 months in prison. She has 4 days of credit. Court finds consecutive service is necessary to protect the public from future crime and to punish the offender. They're not disproportionate to the seriousness of her conduct and to the danger she poses to the public, and her history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. She's been selling drugs for 15 years. She gets out of prison and continues selling drugs. And these are 2 separate incidents, and they deserve to be punished separately. I need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. I'll order the forfeiture of the contraband and instrumentalities set forth in the specifications. I will dismiss counts 2 and 3 as agreed to. I think that's it. Mr. Gagrich, anything else I'm omitted or need to address?
Nothing, Your Honor. Thank you.
Ms. Tomaszek?
No, Your Honor, thank you.
All rise.
Okie dokie, friends. Another not overly pleased judge. Don't blame him, though. Let's go back to Judge Glazer for a few minutes.
250.
I'll leave it at, oh,
250.
$250. The arraignment, I don't know when the arraignment for this one's gonna be, but I'll put December 22nd at 9 a.m. Courtroom 47. Good day, sir.
Your Honor, do you want to add the traffic?
Yeah,
They gave him $500 bond.
include with tap the what is it? One ticket, reckless driving.
This one.
AM9DUTE. Alternate, you said what? 500?
500.
Alternate 500. AM9DU, like umbrella, TE. Next, Marie Stubbs. Page 12. Only 15 pages left. Mr. Stubbs, good morning. You were arrested for carrying 2 counts of carrying a concealed weapon by a felon wearing a mask, burglary to an unoccupied conveyance, grand theft of a firearm 2 counts, petty theft. You're also out on bond hold for F25-17310.
Your Honor, he also has a hold for Broward County.
I will appoint the public defender's office for you. Let me review.
The out on felony bond is from August, so no.
It's armed burglary. He stole 2 firearms from the victim's vehicle and fled. Video surveillance. All right, this goes back to March 14th of 2025. Okay, there's probable cause on count 1 and 2 for armed burglary. No, so that's count 2. That's count 3. Count 1, there's probable cause for
think for one count,
Was that a felon in possession of a firearm or no?
yes.
Where does it say he's a felon? I didn't see that. He is. See it.
I haven't pulled it.
Can you show it to me?
I can't, hold on one second. I just wanted to double check.
What?
I'll pull it, Judge.
Okay. Why can't they just write the stuff in there?
Then they wouldn't need us. One second. All right, let me share it. Okay, so here's a conviction for driving as a habitual traffic offender, which is a 3rd-degree felony.
What is it? F what?
1923880.
What was that date? Yeah, it's not a good
Sorry.
enough. I have to see all that.
Sure. Hold on. It was from August 14th of 2020.
Okay. What was it? Driving as a
HPO.
Okay, there's probable cause for count 1 and 2, possession of a firearm by a convicted felon, 70. What, I split them?
Or just
count 1, 2,500, count 2. Count 3, there's probable cause for armed burglary, no bond. Count 4, there's probable cause for 4 and 5. There's probable cause for grand theft of a firearm, 2,500 each count. Count 6, there's probable cause for petty theft, $150. You'll see your judge Monday, and stay away from the victims. I'm sorry, stay away from Club 24.
I need 1 and 2, please.
1 and 2 is 5,000 and 2,500. Stay away from Club 24 at 3699 Northwest 135th Street in Opelika, Florida. Have a nice day, sir. Next is Kenyatta Session, page 12.
Judge,
Yes.
you're holding him on the other case?
Yeah, he has a probation hold.
It's a probation hold correction?
I thought it was a probation. No, what was it?
So it's out on felony bond,
That's
but that's
Watson.
But this is from March. This case is from March.
the other case is from August.
He also has a hold for BSO.
All right, no hold on F25 17310. No hold. Still being held with no bond, but there's no hold. You too, thank you.
All right, let's go back up to Michigan. Judge Elmore has a fresh contestant, so let's check back in there.
Good morning, Mr. Ennis. You were arrested of cocaine. I will appoint the public defender's office for you. There's probable cause.
Your Honor, Mr. Ennis.
Well, there we go. Things didn't want to switch right.
Thank you.
Have a nice day.
Still not switching right. What in the world? Hold on, guys.
Mr. Ennis is on page 5. Next case.
That was weird. OBS was switching on its own for a moment. I think it's stable now. Sorry about that.
We're here today for a final pretrial agreement. I'm sorry. I don't know why I just said that. I just must have read the word. We're here today for a final pretrial conference. I began to conduct that in chambers with counsel. And counsel told me we needed to go on the record. I'll also note that it looks like just yesterday this court received, and it's placed here in the file, a notice to see consecutive sentencing filed by the people. Again, we're here, and I see that this case includes a felony information with 17 counts as a habitual offender third. Mr. Harrison, do we have any resolution on the case today?
Do not, Your Honor. It is our intention to bring this matter forth for a trial. I believe it is number 1 on the list for the December 16th date, and that it is currently blocked for 3 days.
Okay, let's take a look here. All right, based upon the plea that the court just accepted in the last case, this is the next oldest case here. I'll also note that looks like the defense was arrested back on May 24th. So we are at the speedy trial window, and we'll go ahead and keep it set on the trial date. Anything else, Mr. Harms?
No, Your Honor.
All right. Mr. Salter, I need to talk to you just a little bit about what's going on here. Now, as I do, if you have any questions, all you got to do is let me know. All right. Now, anytime a case comes to this courtroom for a final pretrial conference, it means that the case is set for a trial in the next couple weeks. Generally, it's 10 days. This one, what's the date here?
I think it's the 16th. Did I say that correctly?
I think you did. Yeah. So this time it happens to be a couple weeks out, but that's probably because of Thanksgiving and so forth. Now, on a final pretrial, it's the last day I will accept any pretrial agreement less than pleading as charged. Now, that is never, ever to punish the defendant. It's never to force the defendant to accept a plea agreement. I trust that there have been some plea offers here. That's none of my concern. I don't know if there is or there haven't been, but here's why I do this. And again, it has, well, number one, you know that today the deal won't get any better if there is one, or the offer won't get any better. Next, you know that the next time you come to court, this case is going to trial. And next, when I have to bring in jurors, and we're going to bring in 4 panels of potential jurors, that's 120 people. Now, not all show up, but picking a jury for a case like this requires a lot of potential jurors. So that's 120 people estimated that have to time off of work, get a spouse to take time off of work to come out home and stay home and watch children, do babysitters, somebody who take care of grandma or grandpa if they're being cared for, a lot of other moving parts. Plus, I see that because of the nature of the offenses and how many witnesses I see, that's a lot of subpoenas that have to go out, and those people have to make sure that they are present. I don't know here. I see. Quick look. Yeah, I see that there is an expert witness here. And so that witness is going to have to take time off of other cases and other jobs. There are a lot of several police officers and troopers that have to be pulled off of duty, which is fine. But that means other officers have to go out and cover for them. And so there are just a lot of moving parts. So before I have all those things start moving and all those people make all those changes in their schedule, I just make sure that the attorneys have done their job. That's the key point here. I know now that the attorneys have done all they can to try to resolve the case short of a trial. And that could have been a dismissal. It could have been a pretrial agreement. I've got no idea. I just want you to know that that's where we are today. So that way, when you leave, you know you're going to trial on a particular day. Do you have any questions about what I've just said, sir?
No.
All right, good enough. Thank you. All right. I don't think we have any other motions or issues at all to take care of, Mr. Carnes.
No, Your Honor.
Same question, Mr. Harrison. Anything further?
Nothing further at this juncture, Your Honor. Thank you.
All right. Thank you all very much. We'll see you in a couple of weeks for that trial as scheduled. Thank you. Our next case this morning is People of the State of Michigan versus Caleb Mansfield. This is case number 25-14125FH. Appearances, please. Mr. Carnes, appearances?
Sorry.
It's okay.
Carnes on behalf of the people. I'm Jeff Harrison. I'm here on behalf of Caleb Mansfield. He's joining me at the table.
All right, Mr. Mansfield's in pretrial custody. He's here at the defense table. You all may take a seat. We're here today for a final pretrial conference, and we conducted that earlier in chambers. There are 5 counts, felony counts here listed on the felony information, habitual offender fourth enhancement. This case is one of a couple set for the next trial date. We know based upon that last case that case is supposed to be going to trial. Granted, because I never want to lose a trial date. Some emergency happens, this one could slip into second place. Let me just take a moment here. See that we've got, looks like about 10 witnesses. Still thinking that's a 2-day trial?
Yes.
Yeah, okay. Mr. Harrison, do you
I
agree?
think so as well.
All right. All right, so this is one of the 2 cases set for trial to begin on December 17th. Mr. Mansfield. I have this conversation. Anyone who's sitting here right now has already heard it twice. Whenever we come to a final pretrial conference, that's the last day in which I will accept a plea less than all the charges, meaning the case is going to trial. Or the defendant can always show up on the day of trial and plead guilty. Now, the only way that that won't happen in your file is if the other case goes. We have another case set for the same date on December 17th. If that case does go to trial, then we'll have another final pretrial and we'll come back here. But when it comes to the final pretrial date, my focus is on making sure I don't lose one of the valuable trial dates that I have in a given year. I can do about 24 trials in a year. And so therefore, for the people of Missaukee and Wexford County, the 2 counties I cover, I can't lose one of those dates. So I'll often stack up a couple cases. Your case is number 2. Your case, we anticipate taking about 2 days. The reason why I have this policy is so that I know when I come to, or we all come to a final pretrial conference and we know that this case is going, it makes the attorneys do their job better. At least that's what I think and that's what I believe, so I'm going to stand by it. It makes them exhaust all their negotiating skills to see if they can resolve the case. Now, if they can't, then I know it's going to trial. And so far, they're telling me, if your case goes to trial on December 17th, there is no further resolution. Now, I do this not only to put their feet to the fire, but also because we've got a lot of moving parts. Witnesses a subpoena, officers who have to go serve subpoenas, jurors who have to come in, potentially 30 to 120 jurors. They all have to take time off of work. They've got to get babysitters, somebody to take care of grandma and grandpa, somebody to cover them for work, an employer's got to come in. So there's a lot of moving parts. So before I have that happen, I make them promise to me, at least as of today, if your case goes on the 17th of December, they have exhausted all their brilliant skills. Now, if your case doesn't go on December 17th, we'll have another final pretrial conference. And I'll have the same conversation that I'm having with you now on that date. Please trust that this policy is not at all to encourage or force a defendant to take a plea or anybody to enter into a plea trial agreement. Nothing like that. I don't know anything about the case other than the 2 pages of the felony information telling what the charges are. I don't know how good the facts are. I don't know how bad they are. All I know is that's what your charges. Do not, please do not take anything that I say as any kind of pressure or non-neutral opinion, because I have no opinion about how this case should go. Okay? Any questions about what I've said today? All right, good enough. Thank you. Anything further on behalf of the defense today, Mr. Harrison? Any motions, any discovery issues that need to be addressed?
Depending on scheduling, we may revisit a bond motion, but
Okay.
that will depend on a number of factors.
All right, thank you. Anything further on behalf of the defense today?
No.
All right, thank you very much. Generally, because I have 2 cases set for trial on the same day, and I told you that yours will only go if there's some kind of emergency. Well, you've got almost 3-4 weeks here between now and then. But I'll generally the week prior to, I will tell the prosecutor and the defense attorney, we're going to trial on this one. And for instance, if I say that to these guys the week prior to, then Mr. Harrison can come and tell you, yep, the other case is going. Yours is not going, okay? So I don't wait till the very day, but I kind of give you about a week so everybody knows, so you can take a deep breath, okay? Thank you very much.
Thank you.
Thank you, gentlemen.
Okay, friends, we're going to, I think we're going to go back to Judge Glazer for a few more minutes, and then at the bottom of the hour, we will go ahead and go to Dungeon Court, because it is in session today.
Okay, next we have is Eduardo Rodriguez, page 13. We're gonna be here like another hour. With as many of these. Gosh. Please gonna leave me to drink something stronger than water. I need alcohol. I don't drink alcohol. Eduardo Rodriguez, 2 arrest affidavits. Good morning, sir. Do you speak English?
Yes, ma'am.
Sir, you were arrested for 2 cases, grand theft from September 28th, and then armed trafficking in oxycodone, possession of a firearm, weapon, or ammunition by a convicted felon, possession of a place for purposes of trafficking in a controlled substance while armed, and grand theft of a firearm. I will appoint the public defender's office for you, so let me review for probable cause. The search warrant they found in the kitchen, 40 grams of oxycodone, handgun. All right, so an F-25-25 or F-25-25247, there's probable cause for count 1 armed trafficking in oxycodone. That's no bond. Count 2, there's probable cause for possession. I'm sorry, 1 second. He's probable cause for possession of a firearm by a convicted felon. $7,500 bond. Count 3. Possession of a place for purposes of trafficking in a controlled substance while armed, $2,500. Count grand theft firearm is $2,500. So you're gonna have to go before the division judge to see if you can be released from jail, pending your arraignment or trial. The other case, the grand theft charge, they found a dirt bike in the living room. He said it belonged to him and it was stolen. That bond was $2,500. Have a nice day.
Because we've got a new interpreter, Mr. Barron. Thank
New
you.
interpreter, hi, Ms. Diaz, raise your right hand. Do you swear or affirm you will translate from English to Spanish, Spanish to English to the best of your abilities? If so, state I do.
Yes, I do. Maria Diaz, Florida State Certified Interpreter. Thank you. Thank you for promoting me.
Yes, thank you. You have a good afternoon now.
Thank you. Bye-bye, David.
Juan Sanchez is next. Hi, Mr. Sanchez. You speak English?
Habla inglés, señor Sánchez.
Spanish. Sir, you were arrested for robbery, I said, and snatching, criminal mischief, and battery.
Señor, usted fue arrestado por robo, por arrebatón súbito, daños a la propiedad, daños a la propiedad, sí, correcto.
Sir, can you afford to hire a private lawyer?
Señor, usted puede pagarse usted los servicios de un abogado privado, usted.
Sí, tengo mi abogado privado.
Yes, I do have my.
Do you want me
private
to,
lawyer.
you want to waive a lawyer's presence so we can do the bond hearing now? Or do you want me to reset the case in the afternoon calendar to give you a chance to hire an attorney?
Señor, usted quiere entonces renunciar a tener la presencia de un abogado aquí para poder entonces proceder a hacer la vista de fianza, o usted quiere que lo pase para la tarde para darle chance a usted de que consiga el abogado usted.
Your Honor,
Yes.
he has a hold for immigration.
Okay. You also have an immigration hold.
Señor, usted también tiene una orden de retención por inmigración.
You want to do it now or later?
¿Desea hacerlo ahora o después, señor?
No, ahora, seguimos ahora.
No, right now it's better. We can
All right, sir,
continue.
I'll review for probable cause. Sorry.
Permítame revisar entonces motivo
There is
fundado. No, sí. Sí. Hay motivo fundado.
It actually is a strong arm robbery on count one because he forcibly removed her head earpiece from her headphones from her head.
Nos dice que de hecho es un robo fuerte a mano armado en el cargo
Sir,
número
you
1.
are ordered to stay away from the alleged victim, Oriana Valentina Rodriguez.
Pues señor, usted se le ordena de que se aleje de la víctima, Oriana Valentina Ramírez.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con esta persona directa, indirectamente, personalmente, por escrito, por teléfono o a través de terceras personas.
No contact with the victim through social media or other electronic means.
No puede tener contacto con esta persona a través de las redes sociales ni tampoco ningún otro medio electrónico, señor.
And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Y entonces debe de permanecer en todo momento alejado por lo menos 500 pies de la víctima, su persona, su hogar, su escuela y lugar de empleo, señor.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No puede estar incurso en ningún tipo de actividad delictiva. No puede utilizar ni tener en su poder ningún tipo de droga ilegal.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede utilizar, comprar, tener en su poder o portar en su persona arma de fuego, pistola, arma blanda o de ninguna munición.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe inmediatamente hacer entrega de cualquier arma de fuego, municiones, cualquier permiso de portar armas ocultas a la policía más cercana a su hogar y presentar aquí en la secretaría de este tribunal constancia de haber efectuado dicha entrega.
You may return to the victim's residence one time only within 48 hours of your release from jail.
Puede regresar una sola vez a la casa de la víctima dentro de las primeras 48 horas de haber sido liberado.
You must be accompanied by a police officer
Debe de ir ahí acompañado por un agente de la policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
para que entonces de ahí usted pueda buscar su ropa personal, sus artículos de salud, sus medicamentos, cualquier tarjetas de presentación personales, sus herramientas de trabajo.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Si usted llega a ir a la casa de la víctima sin la policía o si usted se queda allí sin la policía, usted será arrestado. ¿Entiende la orden de alejamiento, señor?
Sí.
Thank you. I'm setting up count one, $4,000. It's probable cause for strong arm robbery. Count two, criminal mischief, $150. Count three, batteries, $1,000. Good luck to you.
Entonces, estoy fijando fianza, 4,000 en el primero, que es robo fuerte a mano armado, 2,000, que es daños a la propiedad en el segundo, y en el tercero, agresión física, son 3,000.
Stage, you have to care if I leave count 1 at 2,500. Are you okay with that?
That's okay, he's got the ice hold anyways.
I'm gonna leave
Okay.
count 1 at $2,500. That works.
En vez de 4,000, voy a poner $2,500 en la primera, en primer cargo. De todos modos, el señor tiene una orden de retención por inmigración.
Just 2,500, 150, and 1,000. Good luck to you.
Entonces, son 2,500, son 150, son 2,000 y $1,000, 150. De buena suerte, señor.
Next, we have Felix Davalos, page 15.
No, we don't have that next. Don't speak for us. Tell you what we do have next, though. That lovely place, the one, the only, where production values are horrible. It's so bad it's good. It's our guilty pleasure. It's a Friday. We've earned it. Let's go to Dungeon Court.
Are you working?
Yes.
What do you do?
I'm a CNA.
Are you paid by the hour?
Yep.
How much per hour?
22.
How many hours a week are you working?
30 to 44.
Okay, do you have dependents?
Yes, 3.
3 children?
Yep.
Okay, well, you're eligible for court appointment. I'll appoint Mr. Steyer to represent you. He's here. We're going to get him in the courtroom so you can meet. We need Mr. Steyer in the courtroom. Mr. Steyer, this is Jody Stone. She's charged with an F2 burglary, so I'm going to appoint you to represent her. Guess we should have the prosecutor come in and talk about bond. Were you cited to appear in court? How did you know to be here today?
I got pulled over in Kanawha County. I didn't have no acknowledge I had a warrant. And then they took me to jail for 16 days out there. They gave me a bond to self-report here. I turned myself in Tuesday, but they said they wasn't no court to come back first thing today.
You went to the jail first? Or?
I came here, but yeah, that's where the court gave me a paper to come here.
Okay, this is Mr. Hill, the Assistant Prosecuting Attorney in Orange County. Mr. Hill, this is Jody Stone. She has an F2 burglary charge from September of this year. She apparently got arrested on a warrant in Kanawha County, was incarcerated there for a while, but posted a bond, came here to the court this past Tuesday and was told to report today, and she did. So what's the state's position on bond for her?
Well, she's appeared on her own, so we're okay with her continuing to be out of jail on an OR bond, Your Honor, or if that is the bond that she posted in West Virginia or here.
I'm assuming it'll be released once she appears here.
Yeah, that would have been on the extradition.
Okay. Since she appeared today on the previous bond, I'm going to let you sign a new bond. I'll set it at $15,000 OR. So as long as you show up, you don't have to waste the money. If you fail to appear, you'll get a warrant, and then you'll be required to pay $15,000 as a penalty. Just come to court if you want to post any new money.
Your Honor, will she need to be fingerprinted?
She will need to be fingerprinted, and Mr. Cooper will give you a form to take to our jail to get fingerprinted. What's
I'm gonna get some paperwork.
What's your preference on coming back for a preliminary hearing?
Can I speak to her just a second about that? We're willing to go outside the 15-day window, Your Honor.
Do you have some dates in December?
Yeah, I'm not available in December until the 12th. That's my soonest, and I've got 12th, 15th, 19th, 22nd.
Any of those work? Do you have a preference?
Let me look.
Does the state have a preference?
No, Your Honor. The 15th is a little clearer than the other days, so rather than stack everything on the same day, we can spread it out, that'd be good, so the 15th.
December 15th will be the next hearing, be a preliminary hearing, 10 a.m.
That's all the arrangements we have for now. Your Honor.
All right, so.
Okay, we're gonna start some pre-trials now, so we need the lawyers and the clients who have pre-trials to be included.
State of Ohio versus Robert Clark, case number TRC 25896, A, B, and C. That's Mr. McCallum's case.
Need Mr. McCallum in the courtroom.
Good morning, Your Honor.
Good morning. Set for pre-trial for that.
Yes, Your Honor. And I don't know if the court has received Mr. Clark's dip completion certificate or not. If not, I've got a copy.
I've got a letter from Lawrence County Recovery.
Yes. So based upon that, Your Honor, and I believe we previously put this on record, my understanding is the state would move to dismiss the underlying OVI. Mr. Clark would plead, there were evidentiary issues in here, testing issues. Mr. Clark would plead to the no contest with a stipulation of finding of guilt as to the ACDA.
There's a safety belt.
And a speed, I think a speed and a safety belt. So that's correct, Your Honor.
Mr. Hill.
And that is correct, Your Honor. One of the things is that the breath score was below .08. I think that there were other reasons why we wanted him to do the driver intervention program. So having done that, we're in agreement with the proposal.
And it looks like Mr. Clark, is he the one that did the striking, or is he the one? Yes. So he struck the other vehicle. Did he have insurance on his vehicle?
Yes, Your Honor.
Allstate, it looks like. Has that been turned in to Allstate?
Yes, sir.
The wreck was turned into them?
Yes, sir.
And do you believe that's all been resolved, or is that still pending with the other person? Do you know?
It's all been resolved. The boy went ahead and got him another truck too out of his settlement.
Should we have anything on that?
We don't have any further information on that.
All right, well, do you want to proceed with sentencing now, or do you want to try to contact the other party? There was looks like a rear end collision.
Well, I mean, we can try to contact the other party. We'll have to get the file.
You want to do that today, or how do you want to?
We'll try to do it today, and I'll let you know in short order whether we can or not.
All right, we'll recall this later in the docket.
State of Ohio versus Devin Stevens, case number TRC 2546, A, B, C, and D, CRA 25628. Devin Stevens.
This is set for pre-trial and preliminary hearing.
So here he is.
Case numbers are 25, 2546, 25682.
Your Honor, it's my understanding after speaking with Mr. Heald that the state would move to amend the felony charge down to, I believe it's an M1, failure to comply. It's going to be the same primary statute number on that. And that would be upon Mr. Stevens entering a no contest with a stipulation of finding guilt as to that, as well as the OVI offense. My understanding is that Mr. Hill would recommend then a sentence of 60 days, suspend 50 to run concurrent on both cases. And then, of course, whatever Your Honor wishes as far as the other attendant matters on fines, et cetera.
Okay. And I'm looking over the crash. There was a crash involved here, but I believe it was a one-vehicle crash.
It was, Your Honor.
This vehicle only was one?
Yes, Your Honor.
And did that vehicle belong to you, or?
Yes, sir.
All right, Mr. Stevens, do you agree with what Mr. McCown has stated to the court?
Yes, sir, Your Honor.
Do you have anything you want to say?
No, sir.
Mr. Yu?
And we agree with what Mr. McCown has represented to the court. We reviewed all the circumstances, and even though it's a first offense OVI, we felt that his failure to stop the officer immediately and him crashing the vehicle in the process was a little outrageous of him, and he should have some consequences because of that, and that's the reason why we think he needs to do 10 days in jail.
All right. There was a lack of center charge, a safety belt. That looks like is either misfiled or was there a passenger? Because the box on the ticket says passenger.
There were 2 passengers.
Okay.
And they weren't injured. The EMS was called to the scene, and they were not rendered any assistance.
Okay. Well, I'll dismiss that one because that's on Mr. Stevens' citation. Failure to control and a left of center. Is he pleading to those also?
Failure to control.
The failure to control, yes, Your Honor.
Moving to Nolly, the left of center?
Yes, Your Honor.
Okay. So left of center is Nolly. Now, on the OBI, the officer checked that he refused to take tests. Is there any?
He was placed under arrest immediately, Your Honor. There was no anything. And then afterwards in the investigation, he had already invoked his right to counsel before they even began an OVI investigation.
All right, on the OBI, then I'll impose a $500 fine for the cost he paid. There will be a 6-month license suspension. That started the day of the incident, October 5th. 60 days in jail, suspended 50 days, 30 hours of community service. Has to go to the 3-day driving school. Is that going to be waived?
I thought that was going to be waived because he's going to jail for both of them. I mean, under the statute, if you go to jail, you don't have to do the death. We did not affirmatively discuss that.
That's what I anticipated that he wouldn't with the school.
Okay, no requirement to go to the driver intervention program. When does he want to report for his jail time?
This Friday. This Friday, Your Honor.
Okay. Well, next Friday, there won't be any court.
Okay. This coming Friday, there will not be?
Yeah, it'll be, that's the Thanksgiving holiday.
Yeah.
The last court date next week is on Wednesday, the 26th.
Do you want to do it the following Friday? Then the following Friday after that, if possible, Your Honor.
Yes, so that's going to be, that'll be December 5th. So he'll report here to the court by 11 a.m. to start his 10-day jail sentence. His review date will be June 1st. So if you finish everything you're ordered to do by June 1st, you don't have to come to the court. If you haven't finished it, you got to show up 9 a.m. Don't show up. You got stuff left to do. You gotta make the deal warrant for not showing up. So, and that's after you finish your 10-day jail. So after you finish that, you should not have to go back to jail unless you don't do the other stuff and don't come to your hearing. So you'll be on probation for 2 years. You're gonna meet with Mr. Major in probation, go over your probation terms. So the safety belt violation was dismissed. On the failure to control, it'd be a $20 fine. The weapon center is dismissed. So it'll be back here December the 5th by 11. I'm sorry. Oh, yeah, failure to comply is amended to a first-degree misdemeanor. I'll impose a $250 fine on that. And additional 18 hours of community service. So you'll have 48 hours to Okay, go check in with Mr. Major. You're free to go.
Thank you, y'all.
State of Ohio versus Aaron K. Wells, case number CRB 25558.
And Wells, is Mr. McCount's case set for pre-trial.
I was told to come. I was a victim.
Okay, talk to the prosecutor.
And then so this case, I filed a stalking case against me for no reason in the other court, and then came in and dropped it. And then here is, see how that one's listed. So what I did is I put a case over that. So that, well, no, but I put a thing over it. I'm not gonna.
Statement. You remember we just needed today to dismiss.
I didn't see it, it was cracked and then it popped out. But it's just one lens, it's one lens and it was cracked and then it popped out.
Courtroom.
Yes.
And here's the thing. My camera was down here, and I was reaching for my water, and he smacked my hand, and my phone went flying. So for me,
That's not anything like it says out of the report, so I'm a little surprised at this point.
that's what I wrote on the statement. And anger management, because we were trial together, and I don't want it to continue. And for her, that's what's great. And do all that. Yeah. Okay, cool.
You need some time, Mr. McCown, we're talking over.
If I could have a couple minutes, Your Honor.
We'll recall it later in the document.
Thank you, Your Honor.
State of Ohio versus Amy Van Zandt, case number CRV 25-456, CRV 25-458, A and B, DRC 25-830. This is Mr. Smith's case. Amy Van Zandt.
Your Honor, I don't know where she's, I had filed discovery on the OVI case. I realized this morning I did not file on the Walmart theft case, which she wanted to take to trial. I filed that this morning. I was going to ask for a brief continuance, but I've had no contact with my client since the last hearing. If we could have 7 days, or I could have 7 days before warrant goes out, I'll see what I can find out. She normally shows up.
Mr. Hill?
This stuff tended for quite some time.
I think there may be a bond.
There might be. There was an OVI she needed to plead to. There's a felony.
She does have a bond up, so we'll be able to get her back.
Okay.
Yeah, we'll ask for bond revocation.
And I'll reach out in the meantime, see if I can't figure out what's going on.
I'll set a bond forfeiture hearing for December 15th.
Thank you, Judge.
When is it?
State of Ohio versus Bobby Adams, case number CRB 25615.
I just got whatever studies they said they have. I don't know what this
Mr.
is.
Stratton's case, pre-trial.
Okay, so we're probably just trying to reset it. I'd like to figure out what this is. Your Honor, the state has offered to plead to the charge. The state's recommendation is going to be 10 days, 10 suspended with 5 days community service. I received some kind of discovery in this, it looks like a flash drive today, so we asked this be reset for another pre-trial.
Okay. We're going to be in December, and
Just the 8th is the only bad day in December for me.
the 19th.
The 19th will work, Your Honor.
Okay, next hearing will be December 19th for the pre-trial. 10 o'clock.
Oh my goodness, where does the time go, friends? It's the end of the day already. I hope you had fun today. I did. Got to see some good court, got to end with Dungeon Court. Things mostly worked today, except the little audio glitch I had on my end at the beginning. So all in all, I'll take it. Let's go have a good rest of our day today, a good weekend, and we'll meet back here on Monday, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. If you're not a channel member, take a look at that. It's $2.99 a month, not too much. You get a lot. Join our Discord. That's up in the pinned chat. YouTube's playing games with notifications. If you join the Discord, then you'll get notifications when we post and go live, so that's very important. But as I said, go have yourselves a great day. Thank you so much for joining me. I look forward to seeing you all on Monday. In the meantime, take care. God bless.